Well, I don't have that.
The audio will be set out. Right? Is the owl set up to pick up his audio? As a mic?
I'm sorry. I don't know.
So what'll happen is when you go to switch it, we're gonna have to redo it again.
Like a bed sheet?
Yeah, hold on, which,
So this is actually, it's saved, so that's.
you tell me when you're all ready. Do we know if it's working for the people who are watching?
We're already in Sherman.
Find out, I'm just making sure it's working for the people who are watching. What I was gonna look at is the audio's, yes, okay.
Look in the back.
Yeah, I know, I saw. What I'm gonna do is the microphone,
There's not a mic here, and there shouldn't be. My mic is external on my camera, which I don't have hooked up.
speaker.
So,
That's interesting. I don't know what'll happen. Oh, maybe that, we'll find out, I guess.
yeah.
All right. We're gonna start the program with the exam because this is our first ever second annual technology program. The American Board of Professional Liability Attorneys has outstanding reporters throughout the country, and as y'all know, we're gonna be combining forces soon. And what I wanted to do for the National Board of Trial Advocacy was to have a program, which we scale programs, which we traditionally do with ABPLA. And I thought, how can I get people to be interested in the program? And I thought, everywhere I travel, speaking about the country, they're like, "You're from South Carolina? What's going on with that Murdoch stuff?" I kid you not. So I wanted to have Eric Land and Ronnie Richter talk about that. They've been involved in the civil side of things. We've got a whole bunch of speakers lined up today, not coming in through the mic, but it's.
You gotta be closer to the laptop to hear you.
Oh, yeah, that's gonna be fun because I don't think he has a mic on that one. Can you hear us at all?
Yeah, I can hear you, but it's.
Yeah, I'm sure the people in here can hear you, but we're trying to figure out if this microphone here is.
Being online, I can hear you.
Okay, all right, so then apparently this is working, so. But, oh. Whatever it is, it's like having 4 wives. So, they're gonna be talking about the Murdoch case and what's been going on. Civil side. We thought that would be of interest. We have people watching it online as well from both organizations, and we hope to have more programs like this in the future. So I'd like to introduce Ron Richter and Eric Leonard.
Good afternoon. I haven't seen a lot of you since I think we were in Miami at the Ritz-Carlton about probably 5, 6, 7 years ago. So thanks for having us. You know, the Murdoch case is one of those cases that, you know, you stumble on or you get once in a lifetime. And early on, Ronnie and I said to each other, you know, we got to figure out a way to get in this case. It was more of a criminal case at that time. And you know, the world thinks of when you think of Alex Murdaugh, you think of the criminal case, you think of the boating accident where Mallory Beach was killed, and then obviously the death of Maggie and Paul, his wife and son. But the civil case is really what drove the Murdaugh case. And every state always has that famous case. In South Carolina, up until the Murdaugh case, we had this Susan Smith. She killed her young 2 lovely boys, drove them into the lake in Union, South Carolina. That was the seminal case. Everybody always talked about Susan Smith, but Murdaugh was just something totally different. It blew up the rules of professional conduct book. But the civil cases drove the criminal case. The murder charges may never have come about, but for the discovery of my podcast co-host of Cup of Justice, Mandy Matney. She was doing some research in the court records and found that there was a death of his housekeeper and there was this $500,000 settlement, but there were no records, no lawsuit, no orders, just a petition that said, will the court on December 18th, 2018 approve a settlement of $500,000? And she stumbled on this article, she wrote about it, And then people started asking questions about Alex Murdaugh. Internally in the firm, so much was going on because numbers weren't adding up. There were settlement checks that weren't accounted for. He was in and out. He's a guy that talks fast. You can never pin him down, but he's so powerful. His family was so powerful. It was a legal dynasty that it was like nailing jello to the wall, trying to understand all his different cases. And, you know, Ronnie's going to talk about this. Hampton County, South Carolina is really a judicial hellhole. In 2005, the ABA voted it the worst, third worst in the country. And settlements that we would get $200,000 for are $4 and $5 million there. And the death of Gloria Satterfield, his housekeeper, very lovely lady, but she made $11.50 an hour. Where I practice in Columbia, South Carolina, and Ronnie in Charleston, you're lucky if you get maybe $600,000 for her death. And it turned out that it was worth $4.3 million. But the point of this case is that when you know, everybody in this room is a really good trial lawyer and has great reputation. When you see a public case and you see that it has a criminal and civil component in it, you want to get involved. And if you're at the top of your game, you're going to get involved. And we got the phone call. There was a Labor Day alleged shooting where he tried to kill himself and say that somebody else killed him. And that's when the law firm discovered or was willing to come out and say, there's a lot of money missing. He ruled with an iron fist in that county. So clients that may have had questions about their settlements were afraid to come forward. He would stamp them down and say, you know, I've gotten you millions of dollars. What do you care? You know, don't question me. And Ronnie and I had spent 30 years suing lawyers. You know, and we built up this reputation through a good side verdict that we got for $5.5 million against one of the largest law firms in our state, and then over 200 settlements suing lawyers in our state. So we got the phone call after Labor Day, and that's really the start of it. So Ronnie.
Yeah, this is, we're all assuming that you all are familiar with the Murdaugh case. So you know the background. I'm from South Carolina. And, you know, for those of you not from the great state of South Carolina, we know that this case ended up transcending the entire country, but the headline is Lessons Learned the Murdaugh Way. So it's more and bigger than don't steal your client's money and don't kill your family. Okay, so good night, everybody. All right, we all go home. But there's a lot to be learned here, and I think this case is going to be studied for a long time for its ethical implications. And we want to dive into the Gloria Satterfield case and explain, you know, that the headline would say, housekeeper falls, $4.3 million settlement is stolen. But that is such a lazy headline. There's so much behind that. Even the concept that this claim was worth $4.3 million. It's crazy how this all transpired. And we want to show you the mechanics of how it is Alex Murdaugh orchestrated the ability, the infrastructure that he had built in order to steal that money. And when we think about our partnerships, I have a partner I trust, thank God. But when you think about your duties of supervision within your own firms, and you think, well, this is a one-off, this could never happen again. Oh, yes, it could.
It happened so many times in that firm. You know, we represented 7 of his victims. And we have a duty written into our rules of professional conduct that we have a duty to supervise our partners. Settlements that come in, you have a duty to make sure that money is dispersed properly. It's not parked in an escrow account. It's not paid off to people who are running your cases. And there's so many different things that we discovered.
Yeah, so let's see how the scam worked. How is it that a housekeeper fell? How did we get $4.3 million and how was it stolen? And so it starts here with Gloria Satterfield. She's the longtime housekeeper of the Murdaugh family. She was a nanny to the boys. She practically raised Paul and Buster. She had a fall on the front stairs. That's what we knew about her. She suffered a serious head injury and she died some days later from those injuries. This is the Mizell house. We all know Mizell. And the cause of death is natural death. There's nothing to see here, sort of. Now, there's lots of conspiracy theories about did somebody push her and everything else, but let's just set those aside.
Well, the other thing also is they had to start out with the lie immediately. She is a housekeeper. If she's reporting for work, it becomes a workers' compensation case. So Alex said, oh, no, it was her day off. She was just coming to pick up her check. So that got it out of the workers' comp thing.
Yeah, and he's dastardly enough to think even then, here's the scam, here's the story. It was my dogs who were loose on the property that knocked her down the stairs, and therefore she and her family have a liability case against me. And so what I'm going to do, Alex Murdaugh, is I'm going to send the boys, her sons, to a trusted independent lawyer who happens to be my best friend, who's the godfather of my son, Paul. And I'm going to have my best friend, Corey, sue me. And that's the scam that we're going to play to get the money.
And they did this all the time. There were wrecks with multiple people in a wreck, they all would be handling, one would handle the driver, one would handle the passenger. Or if they were on other sides of the case. In fact, one of the times, Corey's wife got injured on a boat. Alex represented his wife suing Corey Fleming. So it was this hand in glove that was done all the time in hand. Yeah.
Yeah, and I mean, this is obviously this is a conflict of interest. I mean, even though we're trying to create the appearance that we've sent someone to independent counsel, that's not what really happened.
They never met. The two boys had
yeah.
never met Corey Fleming. There was never a fee agreement. We know in South Carolina and in every state, a contingent fee agreement has to be in writing, signed by the parties. They never met Corey Fleming. All of their communications were with Alex Murdaugh and his firm. Alex Murdaugh set them up. Tony Satterfield, the older son, as the personal representative of his mother's estate, drafted the papers so that he could become the PR, potentially to sue Alex Murdaugh.
Yeah, and I don't know that this conflict is waivable. There was no attempt to waive it, but you've got best friends who are going to sue one another. The godfather of the other person's child. It's an irreconcilable conflict, but for purposes of our ethics credits, we'll make reference to the rule. This is clearly a conflict of interest. This representation never should have happened. Obviously, this is at the heart of every ethical dilemma. Can I do it legally? Should I do it technically? We always like to say when we're having these speeches about ethics, if that lawyer inside of you is saying, should I do this? The answer is probably no, right? And so this is a clear no, but the stop signs are going to get run through. Now in South Carolina, I'm sure like your home state, only the personal representative of the decedent has the legal right to bring the claim. And so the PR owns the claim. And in this case, Tony Satterfield, the oldest son, is the obvious PR, and he's first appointed. Now
it's Alex who comes up with this idea at the funeral of Gloria. She died on February 26th, 22 days or 24 days after the fall. And at the funeral, he comes up to the family, the entire family, brothers, sisters, young children, and says, look, I got this idea. What I'm going to do is send Tony to go to Corey Fleming, and they will make a claim against me, against my homeowner's policy. And I'm going to force my homeowners to settle, not only my homeowners, but the excess.
well, you don't go that deep with them, but I'm going to take care of the boy.
I'm going to take care of the boys. And in this case, Lloyd's of London had the primary, believe it or not, and Nautilus Insurance Company had the excess. It's usually the flip that Lloyd's on the other end.
Yeah, and I don't know what you guys do in your home states, but when people die in South Carolina, we have supper. So we have the funeral. After the funeral, everybody goes back to the house. So if you can picture the scene, we're literally there right after we buried Gloria, when Alex has already hatched the plan. And the plan is there's a claim here. There's a lot of medical bills. She had like 600,000 medical bills from the fall.
It's my hope to get enough to pay the bills and maybe a little bit left over for you kids.
Hope so. But I'm going to take care of the boys, which made perfect sense to the family. And so taking care of the boys means let's get Tony appointed as the PR. I'm going to send him to my trusted friend Corey. Since it's my house, I can't do it technically, although he does. And we get this order that appoints Tony as a personal representative. Now, significantly, that's where the attorney-client relationship is. And so the communications are supposed to take place only with the PR. And only the PR, once we get down the line, can be present or has to be present for any court approvals of any future settlements.
And Corey is supposed to communicate with Tony. None of the letters that Corey sent were ever copied to Tony. Never spoke to him, never sent an email, never met with him. And the pressure that was Alex Murdaugh was under at that time, nobody really understood it. For 10 years, he had stolen millions and millions from some very big rollover cases and other cases on I-95. You'll hear about the Hakeem Pickney case and other cases, the Plyler case, we have that one. So he was making about 10 million a year in 2009, 2010, 11, 12, because he's stealing a lot of money. But then his numbers start to go down because he's not getting the big cases anymore where he could steal this money. And beginning in 2016, he was only making $600,000 a year. A lot of money. You know, don't get me wrong. If you would have told me I can make $600,000 when I was a young lawyer, I would say that's great. But he had this really wealthy lifestyle that he couldn't lead. And this glorious Satterfield case, man, that's the opportunity that we can make some money.
Yeah, so he is at this point, he is his own Ponzi scheme at this point. And so he is robbing from Peter to pay Paul constantly. But this is the one that's going to put him right. And so this is what we see on a going forward basis. Tony only communicates with Alex. Tony doesn't even know who Corey is. The family knows and loves Alex. Gloria was an extension of the Murdaugh family. It was her pride in life to say that she was the housekeeper for the Murdaughs.
Right.
Now, they saw themselves as an extension of the Murdaugh family. And this is where the bond was. So going forward, when Tony had questions about the estate and all the estate paperwork, it all goes through Alex's office. So Corey is on the sidelines from word go. And what we see that's missing in the case, like we see is missing in most of these cases, as Eric alluded to, it is the Teflon shield of a fee agreement. So nobody ever says, this is who's representing whom, this is what we're going to do, this is not what we're going to do. And I don't know what your experience is in your legal malpractice cases, but when we get a file for review, kind of the first thing we look for is there a fee agreement? And more often than not, there's simply not one. And of course, the rule across the country, it may vary from jurisdiction to jurisdiction, is in the absence of a fee agreement, the engagement is defined by the reasonable expectation of the client. So why would any lawyer allow a client to say after a dispute what the representation was about when we had the power of the pen to put it in writing in the first place?
And there was an illicit agreement that Corey and Alex had with each other, where Corey agreed with Alex, I'm never going to actually sue you. I'm not going to file the suit.
No.
I'm going to make the claim. I'm going to write I'm going to write a letter so that you could Tiger River back, which is Alex saying to his own insurance carrier, you're setting me up for a bad faith claim. I'm going to go before a Hampton County jury and I'm going to say, I got this liability. I'm going to be exposed to a verdict in excess of $5 million because that's what the primary and excess coverage was. Who's going to get $5 million for a housekeeper? Not demeaning Gloria, but she made $11.50 an hour. And oh, by the way, just because somebody falls on your stairs doesn't mean you have liability. You've got to show a certain negligence. And guess who? Alex was the one who said, when I showed up, when my wife called me, Maggie called me, and I showed up, I magically got down to Gloria and she whispered in my ear, dogs.
It was the dogs.
The dogs.
The dogs.
He's the only one that heard it. Paul didn't hear it. They were standing right there.
No.
Maggie didn't hear it.
What?
The dogs.
The dogs. All right, so the conversation with the insurance companies is going well. And they have done something in this scheme that's very inconvenient now because Tony is the client and Tony is the point of contact. So they say to Tony, you know what? We're going to have some big financial decisions to be made here, and we need to get a professional in the seat. So we want to invite our friend, the banker, Chad Wessendorf from the local Palmetto State Bank. And he's going to be much better to serve in this role than you.
Palmetto State Bank is where that law firm, Parker Murdaugh, now that is like the Motley Rice of our state as well, has all their money. They're the largest client of Palmetto State Bank.
Yeah.
It just so happens that the president of the bank is also Alex's godfather to his kid. They grew up together, Alex and Russell Lafitte, the president of the bank. So it's all really nice and cozy.
Well, there's three corners in downtown Hampton. You got Palmetto State Bank, you got the Murdaugh Law Firm, you got the courthouse, and they sit right there together. It's very incestuous, and they've run it very successfully for a long time. But now we've convinced, it makes perfect sense to Tony. Tony's a high school educated kid. He doesn't know these things, but we got big decisions. Let's get the banker involved.
But
And
when they asked him to step aside, a month and a half before, they already settled $500,000 of the primary
about to
case.
show that.
And we never told Tony that.
Well, we're about to show. So watch the timeline as we go forward, because the conversation with the insurance company is getting way downfield. We're going to put Chad in. We have to get Tony to renounce first. Of course, he's going to renounce. This is Corey to his paralegal, November 13th. So watch the timeline. We need to hold this until we get the PR changed. And this that we need to hold is the response to the demand to the insurance company. Okay. So we know what we're going to do. Got to get Tony out of the seat. We'll get Chad in the seat. Then we'll progress with the settlement.
Now, Chad had never done a PR for the Murdaugh before. It always had been Russell Lafitte and his dad, Charlie. They had been appointed PRs for a lot of minors and conservators, but he went to Russ first with this, and Russ said, I don't think I'm going to do it this time. Why don't you put Chad in the seat on this one?
Well, and curiously, as you see these probate forms, they're all coming out of Alex's office. When you see Tony signing, he's going to Alex's office to sign. Now, his lawyer is supposed to be Corey, but that's not the way it's working. So we get him out. Here's now Chad's application to become the PR, December 13. Here's the order of the court that makes him the PR, December 18. All right, we're going to talk about the rule of communication. Obviously, the duty of the lawyer is to communicate with a client so that they can make
Meaningful,
they can reasonably participate and
make meaningful,
representation.
informed decisions.
So that
in
obviously never
verification.
happened with Tony.
Never.
Never happened with Chad, by the way, either. But now look at the check. The check, this is the first settlement, December 4th. So even before we get Tony out of the seat, even before we make the application to put Chad in the seat, even before the court puts Chad in the seat, we have a check that's written to Chad as the PR of the estate of Gloria Satterfield.
And in our state, and it's probably similar in your state, a lawyer can only talk to the PR. So once Tony's out of the seat, Corey doesn't talk, has a duty under the law not to talk to any of the beneficiaries, but only the PR. So he didn't want to tell Tony that he had the $500,000.
And never did.
And never did.
And never did. And so here's where it becomes real important too, again, because this is our state statute. I'm sure you have your own. Only the duly appointed PR can prosecute the case. The settlement has to be approved by either the probate or the circuit court. And so that's the next step. Literally the next day after Chad's in the seat, we make the petition to approve this settlement for the 505. And we go to court, not on the record, but we go to an in-chambers conference with a judge with this order approving the settlement with an order that doesn't even reference a case number.
And not filed. So when have you all gotten an order to approve a settlement? It's not, you literally take it from the judge's chambers of the judge's courtroom, you walk down to the clerk of court, you get it stamped.
Well, we used to do that. We don't do that anymore in South Carolina. So here's the disbursement sheet that we shared with the judge. Now the judge has to rely on the lawyers. I mean, the judge can't know that we're about to steal money. And this is the venerable firm in Hampton County. So why would you question any of this?
None of it's on the record, by the way. There's no court reporter, nothing that would indicate how you explain the case, why we're settling for $505,000, $5,000 was MedPay. And the judge usually says, well, is that all the coverage? And no, we actually have another $4.5 million and we're going to go to mediation on that.
Yeah.
None of that is on the record.
Well,
But this is the Bible. Every lawyer knows you get a disbursement sheet, you give it to the court, you better leave that office. Our wives are back there, Robin and Renee, they handle the money for our firm. They cut that check to the penny, the checks to the penny. They don't veer off. If I said, well, cut it to this, no. We can only do that.
No, that's what the judge said we could do. We could do this. And what we told the judge is we're going to take 50,000 of attorney's fees. We're going to pay Chad 10 grand. And we're going to send $403,500 to Forge. And that's, I don't know, if you guys work with Forge in your states? So, I mean, Forge for us is like the leading structured settlement firm. They are the brand.
They're out of Atlanta.
Yeah, so everybody knows the word Forge in South Carolina, but this isn't the real Forge. This is the fake Forge. Because what Alec had done as early as 2015 is he had gone to Bank of America and set up an account in his name under the name simply Forge,
Alex Murdaugh, DBA Forge.
not Forge Consulting, but just Forge. And so when we tell the judge we're going to write a check to Forge for $403,500, that's what we do. But it's not Forge Consulting, the leading firm in South Carolina. It's fake Alex Murdaugh Forge.
And by the way, most judges, when you do a structured settlement, say, can I see the insurance policy? When are you buying the actual insurance policy? It has to be purchased when you're writing a check to a structure. There was no communications with Forge Consulting, nothing in the file.
Not an email, nothing. I said an important event happened in this case on February 24th, 2019. Mallory Beach died. She was a beautiful young lady. She was in a boat with Paul Murdaugh. He's drunk. He strikes a bridge abutment and she drowns. And that's important in this case because that turns Eric's co-host Manny Matney loose, who in her investigation learns for the first time this story about, well, the housekeeper died too, and I thought there was some kind of settlement.
Right. Now, before that happens, the disbursement doesn't take place like the disbursement sheet says. They do this check writing party. Corey decides, I'm going to start stealing money from my partners. So he just writes a different fee check to him and then some cost checks. $10,500 he writes to himself for costs. There was one letter sent. It was a demand letter that was sent to the insurance company for the policy limits. No filing fees, no complaints, no experts, of course, no depositions. And the thing was, when he wrote the letter, and we've gotten back the defense counsel's summary that they gave to the carrier on why they should pay this, it would stun you. You got to pay this money. We have no chance of winning this case. Alex Murdaugh says that he's going to go before a jury in Hampton County and he's going to say, I want you to pay Gloria as much money as you can.
I'm wrong. I killed my beloved housekeeper. I should be punished.
Oh, yeah. And by the way, we can't win in Hampton County. That place is a cesspool. Pay the money.
Yeah, so if you think about the case, if it were a real case, Gloria fell, and a true third-party lawyer was going to sue Alex Murdaugh in Hampton County, and Alex was going to defend himself, that case is worth $0. Exactly zero. Justin knows, right?
But it might be cost you money.
It's going to cost you money. That is worth $0. But Alex flips the script on him at the mediation and says, if you don't pay this money, I'm going to trial and I'm confessing, and that jury will do anything I tell them to do.
That's the second mediation that took place in March of 2019. They have a mediator and they settle for $3.8 million of the $4.5 million policy at a mediation in 3 hours. And part of that is they agree that when the case settles, we're going to do a new petition. And instead of it being Gloria Satterfield versus Alex Murdaugh, we're going to change the caption.
Yeah, it's going to be, hold on. We're going to have a non-adversarial caption.
And we're going to just change it to claims of the estate of Gloria Satterfield. No court order. You just can't change a caption. You have an order, a petition that was filed in Gloria Satterfield estate versus Alex Murdaugh. And they just decide we're going to unilaterally change the caption.
Yeah, so this is what they present. This is what the settlement provided for. So there will be no settlement where Alex Murdaugh was ordered to pay money.
Why? Because Mark Tinsley who is a very aggressive, good trial lawyer, like everybody in this room represents Mallory Beach. And he is up Alex Murdaugh's ass within a week. I want all of your insurance policies. I want your bank accounts. I mean, he's doing everything, and Alex is scared to death. And he's pissed off at Mark because he refers cases back and forth. Remember, I told you that when there's a wreck and there's 4 people in a wreck, there's basically 4 lawyers that do every case. Corey Fleming, the Murdaugh firm, and Mark Tinsley.
Yeah.
And so he's wondering, Mark, why are you coming after me so hard on this Mallory Beach case?
Yeah, but we've now collected 4,305,000. So we have to go back to court again. All right, this is the second phase of the settlement. And just like last time, it's the PR that has to appear. So the boys know nothing about this. They didn't know about the mediation. They didn't know about the settlement. They're not invited to the hearing. But the PR is there to say to the court, I've been involved. I think it's in the best interest of the estate. I'm asking your honor to approve it. And so that's why we need Chad again. So, enter Chad Wessendorf again. That we're going to petition the court. We're going to go back in chambers. We're going to explain that we have another $3.8 million, and we're going to ask the court's permission to accept that money. And here's the check, 3.8 million. It's just a stunning sum of money in this claim. All right, and there's the non-adversarial caption for the petition for the approval.
No document. No.
And all right. And an order approving the settlement is signed in the judge's chamber. It's handed to counsel.
No
Where-
court reporter.
No court reporter. It's never filed of record. So I know the judge trusted the lawyers. This doesn't happen in South Carolina anymore. But this was a point of accommodation between the bench and the bar that, hey, I've got a death sentence or death settlement. Can I come see you? Yeah, come see me in chambers. We'll get it knocked out. It was that kind of collegiality, but it doesn't exist anymore.
Defense lawyer sends the check for 3.8 million. The defense lawyer doesn't even come to the hearing to approve the settlement. The only people that are at the hearing are Corey Fleming, Alex Murdaugh, and Chad Westendorf. That's it. The defense attorney isn't there. And when the defense attorney sent the check to Corey Fleming, he wrote, do not cash the check and disperse until there is a signed and filed order. Corey Fleming cashed the check and dispersed it, and there never was a filed order. That puts you as liability as an escrow agent at that point. You owe duties to Corey Fleming as a plaintiff's lawyer to the defense company, defense insurance company, and the defendant not to disperse until there's a filed order.
Well, here's the disbursement sheet. This is a draft that was not shared with the court. Okay, but this sets forth kind of halfway accurately the financial transactions. This is the one that's actually signed by the court. And this is fascinating because there's a couple of things of note here. Right here. Oh, hold on. It's going to show. So the attorney's fees, remember in the first settlement from the Lloyd settlement, we said the attorney's fees were $50,000. We now say that they're $168,333. Now, there's been no more work on the Lloyd settlement that fee is done
And dispersed.
and dispersed. Another curious note here. When we look at what actually came in versus what actually happened, here's the $4.3 million. Fee splitting versus fee sharing. Yes, it is appropriate for lawyers in different firms to share a fee. But Alex Murdaugh in this setting is the defendant.
Can't
Okay.
share your fee with the defendant.
Which makes any payment to him an illegal fee split to a non-lawyer. So of the attorney's fees that we collect in this case, Corey Fleming takes $672,000 of the $1.4 million in attorney's fees. And the rest gets paid to something called Forge. Okay,
Forge is a P.O. box in Hampton County.
that is true.
Corey's firm, his paralegals, wrote the check to Forge, dropped it in an envelope to a P.O. box named Forge in Hampton County. Everybody knows that Forge has offices in Atlanta and in Columbia, not in Hampton County. And there's no cover letter with the check. Now, every single one of us lawyers, when we send a check, says, dear so-and-so, here is the check holding in trust. This is in connection with the settlement. CC in the client, or even CC in Chad Westendorf, the PR. No letter, no nothing.
Or if you're buying an annuity, minimally, you would think the memo line would say the annuity number or something, but
Because if you're sending it to Forge, who's the insured? What's the insurance policy? If I send $3.8 million to Zurich Insurance Company without a reference, who are they going to apply it to?
well, here's the check. Just simply to Forge for $2.9 million, signed by Alex Murdaugh, DBA Forge.
The defendant signed the check.
And he signed the $403,000 check, and he signed a $118,000 check the same way. This is how you steal $4.3 million.
Now, let's slow down for a second. There was $105,000 of prosecution expenses on that disbursement sheet.
It's right here.
There was no lawsuit. The only thing that took place was a mediation on March the 23rd that took 3 hours. He took $105,000. The judge didn't ask. Now, we have a lot of problems with Judge Mullen. I filed a grievance against her. Wouldn't the judge ask, how does that number come out on the dime? You know, when we all do disbursement sheets, you know, there's medical records, there's service fees, mileage, lunches. It never comes out to the 0-0.
No, but listen, Corey Fleming got sentenced to federal prison on many counts. This was one of them, for stealing $105,000. Now, he also got sentenced to federal prison for stealing $10,000 from the first cut, because again, there were no prosecution expenses. And so that there's nothing else to call that other than theft.
So this is April 13th of 2019. The case should be over. They got the primary policy and they almost max out the excess policy. There's nothing left to do. When you go back to your office, you disperse the money. It's over. You zero out your escrow account. Corey kept
Right here. By our math, there was about 128,000 still just kind of hanging around. Turns out it was a smidge more than that, but we were close.
he kept in his escrow account for another year and a half.
Well, and when the stipulation of dismissal was signed, it's Alex Murdaugh signs his own stipulation of dismissal, which is also just kind of amazing.
Not by the insurance defense counsel that was appointing him. And they stipulate and dismiss the case on the same day that they deplete the escrow account of the remaining $118,000.
Yeah, and here's the rest of the money you cut from Corey to his paralegal. We're now able to send additional money to Forge in this case. See me tomorrow.
Later.
Yes, see me tomorrow about issuing a check to Forge, identical to the large one we last sent. The last check was for 2.9. We have 231 left. Look at this. Alex is supposed to be sending the carbons back.
Alex.
Alex has not only his checks, but the carbons to his checks. So I don't know. A lot of problems with this. Obviously, there was a lot of press around this case. There were also some bar complaints around the press around this case.
Yeah, I have 2 bar complaints against me. Pending.
All right, and just to refresh the rules about the use of the press, that started in 1991 with the Gentile case, and the test is what you're saying, does it have a substantial likelihood of material prejudice? That language is mirrored in Rule 3.6. I would say no, that in the white noise environment which we live, how could a lawyer saying something, how could you reasonably believe that you're going to substantially materially prejudice a proceeding that might be a year or 2 years down the line, especially in this case, where how many articles were written?
By the time Ronnie and I came on September 13th, there had been over 1,500 articles written by Alex Murdaugh, none being positive, by the way. Everything being that, that he is a robber baron. And the thing that was important was we knew that pressure breaks pipes. And the only way we were going to push the prosecution, the state attorney general, to get involved was if we were able to show this rampant theft. So Ronnie and I actually met with the Attorney General and the investigators and educated them on the theft. And I went on TV solid for about 2 months straight. There was, we filed a lawsuit because when we even asked for the file from Corey Fleming, he wouldn't give the file to us. He claimed that it only can go to the PR, it can't come to us. We didn't represent the PR, we represented the estate. So Ronnie and I said, okay, fine, don't give us the file. We're not people that write Hallmark card letters when we write to a lawyer to ask for a file, but this one we stepped gingerly because we didn't believe it, that there was this kind of theft. So we said, we'll give you the Monday to give us the file. They didn't give us the file. Tuesday, we filed a lawsuit because then we would have discovery rights and subpoena power.
Well, there's an important safe harbor in the rule, and you guys know this safe harbor. A lawyer is permitted to say something that's necessary to correct a false narrative. This case was nothing but a false narrative. I mean, everything coming out of the defense camp was a false narrative. And so, yes, the decision was made that we had to correct that publicly every single time,
And
that we couldn't let any of those stories run.
I have a great relationship with the press, both locally and nationally. I love the press. I think if you're honest with them, they will be honest with you. And if you have a good story and you can provide them with information, not off the record. I don't like going off the record. If I'm going to talk, I'm going to talk. And they carried the water for us, and they put a ton of pressure on our state representatives and our law enforcement. You got to be charging Alex Murdaugh. Forget the murder, forget the roadside shooting. He stole that kind of money from his housekeeper. And then all of a sudden we started getting phone calls. Well, you know what? He stole money from us. And we had Gloria Satterfield's sister, he stole $28,000 for it. His childhood best friend, Jordan Jenks, he ripped him off for $108,000 on a case. And then we also got the statute of limitations cases. So many times he missed statute of limitations to file a suit. We get people who are calling us on the phone saying, we were injured in 2016. Alex is telling us our case is pending. We look it up. There's no case pending. It was way past the deadline.
Yeah, and that's another important safe harbor in the rule, that you can enlist the public's aid to investigate or seek evidence. And so as we're out there, getting our message out, A, we're correcting false narratives. B, we're asking the public, if you have information about this, please contact us. And yes, to Eric's point, we got tons and tons of contacts. And if you watch the Murdaugh trial, you know how prominently the financial crimes featured in that trial.
The murder trial.
That was literally our file. We literally sat down with the FBI and with SLED in our state and gave them the financial crimes information that they used as the motive for the murders.
And it was such rapid fire. I mean, I was doing 6 to 7 interviews a day, and Ronnie's in the background trying to keep up with the interviews, calling me on the phone saying, Eric, you can't say that, be careful, pull it back,
said a lot, yeah.
pull it back, and then Ronnie's always saying, well, it's because he's doing this. We're trying to get witnesses. Here's the false information that Dick Harpootlian and Alex Murdaugh was out there. But you got to really be careful when you're talking on the press, because people will file grievances against you. Not only the people that you're talking about, but other lawyers.
All right. And in 45 minutes, that is how you steal $4.3 million. So that's our story.
There could be a hand signal. There were 2 incredible things you said. One is that you had to get Eric to calm down.
Yeah, well,
that's incredible.
Yeah.
Also, I don't know if anybody picked up on that. Did y'all hear when Eric filed a grievance against a judge? How many of y'all done that?
Was there, like in the Satterfield case, was there an actual document filed with the clerk of for the
The only thing that's ever filed is that original petition for approval of the 505.
Okay.
There's never anything
And
after
then
that.
the dismissal.
But that's what Manny found.
So when we came on board, we we said, okay, how are we gonna get the money? So Alex isn't gonna have any money. So we recovered, a total of $9.4 million.
From various sources.
From various sources, from law firms, from banks, from Palmetto State Bank. We got some money from Alex's firm. We got some money from Corey Fleming individually, from Corey Fleming's firm,
A
from
lot of sources.
Chad Westendorf.
A lot of confidential sources.
Yeah, but yeah, no, we recovered $9.4 million. So the kids are better off by the theft. But here's the most unbelievable fact. It really drove all this. When Alex is sitting on this money, Brian Harriet, who is a vulnerable adult, the younger of the two siblings, he's, he's got intellectual mental issues. He calls up Alex and says, I'm getting kicked out of my mom's mobile home. There's a $17,000 mortgage. Is there any money coming in the lawsuit? Otherwise, I'm gonna be living on the street. And Alex said, no, I'm fighting real hard, but there's nothing that came in yet. He got kicked out onto the street.
That's what always amazed us. If they didn't give these boys any money,
$50,000.
$100,000, and there was been a king's ransom.
He took it all.
Just kind of following up on that, since you have somebody who electoral challenge, the court should have appointed them item
Sure.
to represent.
Never happened.
Never
Never happened.
And typically, my limited experience in that line is that, I mean, the judges always wanted to hear from me, chapter and verse, you gotta go through. So-
This was just how crazy it was in Hampton County, you know. and so-
Do you all do settlements not on court record, or you always make sure you're on court record?
Not for minors in confidence.
We used to go off record. We don't do it anymore.
Yeah, no judges will do it.
Yeah.
What happened to the dogs? No.
Oh, and now, no, here's the thing.
We'll have a teaser. We got a question and answer toward the end. So we'll have more questions.
But I just want to say one thing. Now Alex is saying in federal court, I lied. The dogs never did the fall. She fell on her own. So therefore, if you want to get back the insurance money, because Nautilus and he's getting sued by Lloyd's. If you want to get the money, go to Eric Land and Ronnie Richter, or go get it from the Saturdays, because there never was one.
Alex is now saying the dogs are barking up the wrong tree.
Yes.
All right, so our next speaker, I think it's set up, is Bill McMurray, who's gonna be talking about more legal malpractice, because there's nothing more that lawyers want to hear about other than how to commit or how to avoid legal malpractice. I can talk more about Bill. He's been a mentor for me. Known him probably more than 30 years. He helped acclimate me to the ABPLA, and he's an outstanding speaker, and I hope you enjoy what he's got to say about
Thank you.
legal malpractice, and you don't get too nervous.
So a little bit about the broken road, as they say, that led me straight here to you today. So back when I was 23 years of age, too young to be practicing law, thought, I want to be in a court. I want to be around juries. My grandmother said to me, son, look at you. You look like you're 12 years old. Ain't nobody going to believe in you. And that discouraged me for a bit, but I went ahead and pursued an opportunity to be a prosecutor, to be a district attorney, what we call a commonwealth attorney in Kentucky. And so I prosecuted for 3 years every single violent crime that can be committed by one human being on another to jury verdict. We're talking pouring pure sulfuric acid on your boyfriend to kill him. We're talking strangulation murders, rapes of a 3-year-old, all the terrible stuff. And I thought, I just can't do this. So I thought, well, how about doing some defense work? So I started in a large insurance defense firm after 3 years of prosecuting, and I defended hospitals and doctors. And after about 3 years of that, I felt like, this doesn't fit either. I don't feel like I'm actually fighting for the people who are the victims of people whose trust has been abused. So suing hospitals, suing doctors made more sense, and suing lawyers made more sense. And so that's kind of how I developed into the trial lawyer I am today. We're going to talk about, though, a particular high spoken duty that we owe to our clients. And before we get there though, back in the eighties when I couldn't do any more, of what I had been doing, prosecuting, I got tired of the insurance defense world. I quit practicing law for a while. And I moved to Florida. We got licensed and then came back and after, being disappointed in the defense work, I was practicing in Florida, taking the cases for the first advertising plaintiff's firm in the state. And it was a good opportunity for me to learn the plaintiff side, knew the defense side. And in that role, I'm living in Florida and I'm reading the news. This is the period in our history, you may recall, when insurance companies were paying for billboard ads and all kinds of advertising on radio and television to demean and disparage trial lawyers. It's what drove the phrase trial lawyer out of our lexicon. And one of the things that struck me the most, and I'll never forget it, is reading the Orlando Sentinel. I think insurance companies were actually paying newspapers to run these horrible op-ed pieces about trial lawyers. And this particular one referred to trial lawyers as prospectors, gold diggers. Prospecting in a wasteland of torn flesh and bitter tears. And those words stuck with me immediately. I thought, is this where I'm headed? Is this really what I'm doing? And so despite the connotation and the disparagement, I pushed on and really became enamored with what we call specialization. Specialization is what this case we're going to talk about is about today. Prospectors, plaintiff's lawyers that handle car wreck cases or any number of personal injury cases have a special duty that they cannot avoid by saying, hey, I specialize in this area of practice. I don't work in the other field. So I don't owe my client a duty on these other areas of practice that perhaps I should pick up and recognize. The client is going to suffer damage if I don't advise the client to maybe find one who specializes in another area of practice. So today's presentation should sober up just about any trial lawyer, especially plaintiff's side. So we're going to talk about the trial within a trial. That's really what it is. The case within a case doesn't really say it. It's a trial within a trial. And what it means throughout this country and in most jurisdictions, very literally, the first trial, the jury is presented with the evidence of the underlying case. And let's use the example we're going to talk about today, where the underlying case is a medical malpractice case. And in that trial within a trial, phase one, you only get to try the medical malpractice case to the jury. Now, the defendant lawyer who's on the hook is sitting there. The jury is scratching their heads over, well, where are the doctors in the hospital and all that? Well, they're not here. It's all a big fiction. It's very confusing to juries, but it's where we are today in most jurisdictions, how these cases are handled. And we're going to talk about some of the problems with the trial and the trial. But the bifurcation concept is phase one, you try the malpractice case against the hospitals and the doctors, and you bring it to verdict. Jury comes back, they find in favor of either the doctors or the plaintiff, and then they hear the evidence of what the lawyer did wrong. The problem with this concept is pretty obvious, because the defending lawyer is rewarded for the most serious neglect of his duties, right? I mean, losing evidence, not preserving evidence, witnesses getting lost, their memories being lost. And an example, a good example, I think is a very visual example, is in Keeney v. Osborne, a case that's famous in Kentucky that our Supreme Court wrote this opinion in 2010. An airplane falls out of the sky, crashes through the roof, and literally the engine lands right beside the lady in the home who's in her rocker, no kidding, knitting. It doesn't hit her. No piece of anything hits her. There's been no contact. And while that case is about the contact, the point is the plaintiff's lawyer who blew the case, blew the statute, and it became a legal malpractice case. The plaintiff's lawyer, in that particular case, had lost track of the plane. So it got crushed and salvaged. So there was no airplane to examine to determine why it fell out of the sky. We know it's negligence for a plane to fall out of the sky. So all they had was the pilot, which was a shallow pocket, to say, compared to what might have been if you could have sued the FBO, or you could have sued whoever rented the plane, and you knew that there was a problem in the paperwork. Right? So, also couple this with the problem. Most of the lawyers we find that do a terrible job and make it hard to prove the underlying case are also uninsured or underinsured. Because the first thing we do when we screen these cases is we go and see, well, we check the website of the Bar Association to see if there's insurance. Because we can't drag clients through these very lengthy litigation cases without some assurance there's going to be money at the end of the day. So additional problems are causation. The burden of causation falling on the plaintiff. We know that 99% of all cases settle, but we cannot put on expert witnesses in the trial within the trial environment. You can't put on experts to say the case would have settled and the settlement value would have been. And you let the experts battle it out in front of the jury. Maybe in Georgia they do that, but this is what is so contrived about this trial within a trial concept. It's evolving in some states being more fair to the plaintiffs. But the last item of a mess in this entire trial within the trial is collectability. So some states like Louisiana say, you know, we're not a case within a case state. Louisiana is not. Courts have said we're not. Therefore, we don't believe that collectability is an issue. We think that it's speculative. So nobody gets to talk about collectability. But in virtually all the other jurisdictions, if you can't prove that you would have collected the verdict that you were entitled to, it doesn't, you're going to get nowhere, you're going to lose. So then we have some states that say, well, the plaintiff has the burden of proving collectability as part of their prima facie case. Other states say, no, it's direct, it's an affirmative defense. And once the defendant has put on proof affirmatively, then it flips back to the plaintiff to prove, well, I could have collected. I like the argument that Louisiana came up with in collectability, and they say, look, you get a judgment against the deadbeat. You don't know that he won't, for example, win the lottery. So it has value, even if it appears to be uncollected. So that should be the way things are resolved. The problem is they're not, and it's slow to come about. The case I want to talk to you about today is a Kentucky case decided in 1978. So this is a long time ago. The first case in Kentucky to deal with the issue of legal malpractice came out of the Court of Appeals in 1972. So we had very little law to go on in 1978. Daugherty versus Runner involves initially a car. Mrs. Roach is driving her car. She crashes. Somebody ran into her. They were at fault, not she. She spends a month in the hospital and dies. Her husband, Mr. Roach, hires Mr. Runner to represent their interest in the wrongful death case. Makes sense so far. And so a contract is entered into. This contract says what all contracts say, what mine say, probably most of you, that we're going to represent you against any and all responsible parties. Later in this crazy case, a second attorney shows up. This attorney is going to handle the medical malpractice case. So there are two claims here, wrongful death, car wreck, but there's also a medical malpractice. But the lawyer who had contracted to handle the medical malpractice case blew the statute of limitations. You're thinking, well, why are we talking about that case when it's a car wreck case, and Mr. Runner represented, Mr. Roach, the executor of the estate of the car wreck case. Because when the statute of limitations was blown, Runner files his wrongful death suit on the car wreck case, years after the statute, the 1-year statute had run in Kentucky. Mr. Runner said, he wasn't hired to represent the estate of Lula Roach in a medical malpractice case. And he's reminded of his fee agreement, which says, if you're going to represent for all claims against any and all responsible parties, then obviously, if there's malpractice involved, you need to know about it, you need to advise your client. Roach says, I never advised my client on the medical malpractice case. I don't know anything about medical malpractice cases, and, well, as the proof will show, someone else did, and they blew his statute. So, he even goes so far as to say, I didn't examine the hospital records. I wasn't looking at that. And the appellate court, our court of appeals at the time was our highest court, they said, well, the statute begins to run when the medical record of the patient, when that treatment's fully complete. And of course, that was shortly after the hospital stay of some 30 days. Well, we get to what is disturbing and worrisome about this particular, opinion. In this case, the Court of Appeals says, what you read there, and this is why that in every single case, not just in Kentucky, but this case has been picked up in every state because it makes sense in the end. You're not going to get a judgment in your favor as the lawyer because you excluded it from your contract or because the plaintiff went and hired somebody else. If you were involved in that case, you had a duty to read those medical records, know there was malpractice, and if you're not competent to find the malpractice, you've got to refer it to someone else. That is a tremendous burden. But is it unfair to place a burden that high on us prospectors in the wasteland of torn flesh and bitter tears? I think not. So the court, well, let me just throw in here. After the court wrote those words, as you see up here, the court said this, making it clear, an attorney cannot for himself, an attorney cannot completely disregard matters coming to his attention, which should reasonably put him on notice that his client may have a legal problem or remedies that are not precisely or totally within the scope of the task being performed by the attorney. Precisely the situation. He had the medical records. He didn't say, I'm not representing you in a medical malpractice case. So the court simply is ruling, no matter what you do, you're going to wind up in front of a jury. If a statute of limitations is blown on any portion of the case that involves that set of medical records. This case unfolds further with the standard of care, we all know, which is nothing of a surprise here. I like these words. We have a duty as trial lawyers, plaintiffs, anyone, to exercise the most scrupulous honor, good faith, and fidelity. I love these words. They're not found in any other case that I've ever seen. I use them all the time because they do resonate with the trial. And that's why this case is worth considering and reading carefully. The courts at that point hadn't had any cases like it. And so they went to a 1916 opinion, a landmark decision on how we handle legal malpractice cases, and the elements were derived from that particular opinion. When we get into the trial of the case, it gets even more bizarre. Mr. Runner, the plaintiff testified, Mr. Runner, the defendant lawyer testified, that he wasn't competent. And then, hey, the records weren't complete. There wasn't an autopsy report. And the courts rejected those arguments and said, well, it's up to the jury to decide, Mr. Gardner. He also testified that, well, no one called his attention to the possibility of a medical malpractice case until this second attorney actually phones him up and says, hey, I've got the med mal case, you're handling the wrongful death case. And the statute of limitations, both that lawyer and runner knew statute of limitations was about to run, but it had not run. What did runner do? He testified, I said, I told him to go ahead and file it. Well, it didn't go well, because it didn't get filed. So the case within the case, med mal case was tried, and I know this, it's not in the opinion, but I know well the trial judge that handled this case, who later became a court of appeals judge, Mike McDonald, who testified for me in many legal malpractice cases over the decades. And it was Mike's idea. There wasn't anything for him to go on. Mike said, make sense to me, and it was fair to the lawyer. Just try the case as a medical malpractice case. Let the jury make the decision, and then we'll present the evidence of the lawyer's misconduct. Because if there's no medical malpractice case, then I'm not going to waste my time hearing the evidence and besmirching the reputation of the lawyer in a public arena. Protecting lawyers always. So that's what Mike thought was a good idea. It became the gold standard. And it's still the law in Kentucky in most jurisdictions. Well, the jury found in favor of Mr. Roach on the underlying med mal case. And they awarded money, etc. Which is not really an award, it's just a statement of what the case was worth. On the legal malpractice instruction, before those instructions were given, experts testified, the expert testified of runner's failure to inquire into the cause of death. So if you have a wrongful death case, we are duty bound to investigate to determine the cause of that death, because there may be medical malpractice. And his failure to review the medical records. Well, he did review them, but he didn't review them before the statute of limitations ran on the case he thought he wasn't representing on. He had no idea. He had no reason to believe. No one had told him about med mal until he heard that there was this other lawyer that had been hired to handle the medical malpractice. And wouldn't we all have been so relieved? No, good, I'm glad I'm not handling that case. The fact that you can't even defend, other than in front of a jury, you can bring all this evidence to the jury, but you're going to be sitting in that courtroom under these circumstances. And that's what the trial within a trial brings to bear. And this court goes on and makes sense out of it in some way that I think is relevant to all of us in this room. But before we get to that, Mr. Roach says he's bizarre. I was aware of the statute. I contacted two attorneys in Lexington and they declined the case. I knew, and he actually hires another lawyer. Yet, Mr. Runner is still going to be forced to sit in the courtroom and see what the jury does with his failure to make sure the statute wasn't blown. And that's really what it came down to, make sure the statute of limitations wasn't blown. So, the second attorney actually turned over the case to Roach's current attorney, who filed the medical malpractice claim, of course, after the statute was blown. And Mr. Roach, again, he knew the statute of limitations statement. The specific duties that were given by the court, are what you might expect. If you have a duty as a lawyer taking a car wreck case, to associate with lawyers who are competent to handle the other aspects of that case. You pause for a minute and go, how do I avoid this? Can I put in my fee agreement that says I'm not handling a medical malpractice case? I think you can put it in there, but if you don't tell the client that they have a potential medical malpractice case, are they going to go inquire of another lawyer? So you can't really insulate and protect yourself by putting those kinds of disclaimers in. I put in now in mine, I'm not handling any governmental claims. Social Security, disability, not handling any work comp. But if there's a work comp case that's in your face, guy gets hurt on the job, are you not going to tell that client and usher them over to a good work comp lawyer? Of course you are. So it isn't just enough that you put in your fee agreement that we're excluding all these other aspects. It is quite a burden, but I think one that we're responsible for. The beauty of this case is that Mr. Runner got off. Right there, got off. Jury said, no, you're not responsible. Hell no. Listen to the evidence. I mean, he hired somebody else to handle the Med Mount case. How could Mr. Runner possibly have lost this case? There was no way he was going to lose this case, but he had to sit there for 2 weeks and suffer through this indignity. And it's still the rule today. It has been looked at by our courts. Now we have the Supreme Court. They've looked at it countless times. It is still the law today. And it's a bit scary for people to hear it for the first time and to see this analysis. But what I really want to talk about, what really excites me and chills me, is what the Court of Appeals felt. They wanted a verdict against lawyer Runner. If they had been sitting as jurors, they would have found Runner accountable for blowing the statute of limitations when he took this case initially. And why? So the court does something really bizarre. Never seen it. 1978, this Court of Appeals says, we would add, we agree with a statement that the appellant's lawyer made in his well-written brief. That's high praise, well-written brief. So what in the hell did this attorney say? I mean, you just can't wait to turn the page. What did he say that had this Court of Appeals all impressed? You gotta love it. This is in the brief. This is Roach's lawyer's brief. Lost the case ultimately against lawyer Burke. Perhaps the issue that is involved in this case is far beyond the instant action. It must be laid at the doors of the bar as a whole, and more specifically, Runner himself. Runner's lawyer. I mean, this is Roach's lawyer talking about Runner's conduct. Maybe we as a profession have not discharged our responsibility. We specialize. We specialize. And this is 46 years ago, conduct that this lawyer engaged in 52 years ago. And they go on to say, however, in the end, doesn't the public have the right to expect and demand expertise and specialization? And we all know what happened 20 years later, 18 years later, in the year 1990, because that's why all of us are here today. Because of one event in our judicial legal system. One event. This case brought us all. And it's exactly what the Court of Appeals of Kentucky was talking about. In their lauding the lawyer for saying, this is a problem for our bar association. And it's one that needs to be addressed. And 20 years later, it is addressed finally by the U.S. Supreme Court. When all Mr. Peel did was put on his damn letterhead that he was board certified as a civil trial specialist by the National Board of Trial Advocacy. What a hell of a thing. And let me just share with you for a moment what happened to me. I got tired of showing up every Monday morning as a young lawyer after leaving Florida. And I was in Florida, you didn't have these things called motion hours, these case calls where you go in and get a date to be heard. It's all done on the telephone, for God's sakes. It was reasonable. So I write the Chief Justice of our Supreme Court, Bob Stevens, a nice letter saying, hey, I just came back from Florida. But what a great idea. I was grieved because I said I was board certified by the NBTA. Yeah. And you know what our rule read at that time? Our rule actually read that you have a right only to call yourself a specialist if you are board certified by any organization approved by the U.S. Supreme Court, and our ethics rule cited Peel versus the Illinois Attorney Disciplinary Commission, and yet our Supreme Court wasn't even aware. We've come a long way, guys, a long way. A state may not completely ban statements that are not actually or inherently misleading, such as certification by a specialist, as a specialist by bona fide organizations such as the NBTA. Peel's letterhead was neither actually nor inherently misleading. There is no dispute about the bona fides and the relevance of the NBTA certification. And ain't that the damn truth? Anyway, we're all here. The broken road led us here. That's all I got.
A good tag to put on our website at the bottom.
Yeah, exactly.
I'll let Grace is gonna introduce our next speaker, so I don't mess that up. And I'll let John get the.
Thank you. Put him on the website.
Just want to let everyone know, we have some quick little snacks out here. If you guys wanted to grab a snack, come in, up to you. And they're just so you know, yes. A little refuel before before we start up again, give them a couple minutes. Yeah. We're a little ahead of time, so I just doesn't snack. 5 minutes. Okay, they're gonna grab and come back in.
Let folks on the webinar that we're just taking 2 minutes just to change over speakers. So folks who are online, we'll be back in 2 minutes. Good, thanks.
You're right, we're having come back. That's my 30. I know we're ahead of the game.
I was kind of interested.
There. Oh, yeah, I'm by myself.
Seems like.
Yeah, the is, but if you had this was those people that write the contract and say are not special ed, and third party cases.
And it's sad, what we were talking about. If you have to, I'm not gonna get everyone like that.
Right.
I know.
It's like,
You know, I had to hear if there's another.
yeah. What do you think about small people that was really shit?
I like that.
I know, it's a real, put it over there on the website.
The BLK,
Right.
like, why would you be looking for a pot of gold? Everybody works. It's like getting.
Yeah, it's
really. I just want to. I didn't see that.
No, his, I had it set up, so he's on this computer and this is here, and you know, sending from the main screen. So yes, it was 50% of those.
And actually begins to.
Okay, I extended it. I said, no.
So that's my. That makes sense.
Right.
Right.
All right, let's, you got a belt for people out here?
I'll get it. You want to start off?
Well, Grace can introduce this stuff.
It's like, it's like. Between breakfast and lunch, like between lunch and that to eat, and between lunch and dinner, between dinner and drinks, so it's just. Like, I don't have that relationship anymore. I didn't resist that. It's donuts. It comes north. I've had to discipline myself in my 5 years now, you've been over trying out what I eat, when I eat.
Yeah, there's.
Because it's so easy to just. When you get to be all right.
Yeah.
Tragic.
Great, you want water in?
And what?
Good, I got some water.
I stopped drinking out.
I was asking the speaker.
Oh.
I'm good.
Okay, sure. Okay, whenever you want to start back.
Yeah.
My life stuff.
But we're still online, so whenever you want to start back.
Yeah.
It's right there, that house.
Don't worry, yeah. Alright, I'm gonna do a little advertisement, if anybody's not had the Garrett popcorn, caramel and cheese, perfect mix. With the crack. Literally crack cocaine out there. Yeah. You will be covered in orange from the time you that will be happy. Alright. Grab one for me and I can splurge. It's all the calories out of her speaking.
So should I go?
Yes, ma'am.
Ready? Okay, so I'm Grace Weatherly, I'm a claims lawyer in Denton, Texas, and I do claims med-mal for 31 years. And Dr. James Rochelle is here from Charlotte, North Carolina. We have worked on a case for the last 4 years that I think brought some very interesting issues to the forefront that I want to share with you today. With the world being what it is, today's the first day that we met in person. So, I want to talk to you about a little bit about the environment which arose, and it is in the behavioral health institution. I've got a few slides. There are very few slides. They're mostly stats, but really the point is simply to illustrate for you that the amount of people who are living with mental illness is significant, 20% of Americans. We've had over 1.2 million inpatient hospitalizations in 2021 in behavioral health institutions. 2 million emergency department visits in 2021 for mental illness. So all of this stuff you can see tied to 2021, as you probably read, there was a big crisis in mental health care brought on by an influx of patients due to COVID and shutdown. 20% of all emergency department visits are mental health related. So just, wrap your head around that. Here is an article I'm going to give you a few excerpts from JAMA, the Journal of the American Medical Association, talking about, this is a study among youth. So the case that Dr. Rochelle and I worked on together was for an 18-year-old who was institutionalized in a mental health facility there in my town, Denton, Texas. Over the last 10 years, the proportion of pediatric ED visits for mental health reasons has almost doubled, including a 5-fold increase in suicide cases or suicide-related visits. There's an urgent need to improve this crisis in emergency mental health service capacity for young people, especially for children with suicide symptoms.
Just to give you guys a quick context of some of these, what we're seeing. So I work at, like you saw on the slide, I work at Wake Forest University. I also work for Atrium Health. Joint now, Atrium Health is the largest hospital system in North Carolina. Part of ABPLA Health is the third or biggest not-for-profit healthcare system. So it's a huge system, wrapping all the way from down here in Illinois to Georgia. So it's got a large plant. But we also provide more behavioral health care than anybody else in the state of North Carolina, or North Carolinians. We are seeing a real crisis with both pediatric patients and adult patients in our emergency departments. To the point now where a lot of times, if you walk into an ED, it's packed. Some of that's flu and it could be flu and COVID, but it's also, we're seeing just an overwhelming amount of behavioral health patients that are in these situations. So it is astounding. A lot has to do with COVID, even social media has a piece to do with it. And so there's a lot of things right now that are really compounding that issue.
So I was gonna introduce you at that point, but that's great. He's told you pretty much. I could spend our 30 minutes of a lot going over his CV. He's so very well qualified. I won't do that. But he is the chairman of the Department of Psychiatry at the Carolinas Medical Center, the medical director of Atrium, which is how many beds at the Charlotte campus?
We've got about 115 Charlotte, which isn't near enough, and hasn't been increased in the last 20 years.
And he's also an associate professor at the Department of Psychiatry, and secretary of the American Association of Psychiatric Administrators. So I was looking far and wide for someone who could talk to the jury about how a behavioral health institution is supposed to be run. And with good luck, because of his professional association, I came across Dr. Michelle. I wanted y'all to have a chance to meet him. At the beginning of the slideshow.
You keep talking, so rules thing over here. Okay. You keep talking.
If they, you're not bothering me, no, just. No worries. The first slide and the last slide is Dr. Michelle's contact information. He also, a group of those psychiatrists in that group have their own forensic group, so they are available for helping you on cases. But why don't you talk to them about the entries in psychiatric hospitals? This is more of the, you made it where it didn't work now.
But I didn't know. All I did was.
Yeah, I'll just kind of speak a little bit about psychiatric injuries. Psychiatric hospitals are a little bit different than a general hospital for a number of reasons. But they also tend to be, I would say, a little bit more dangerous a lot of times. You do have your typical injuries. You can see, obviously, medication errors, or medication where the medication isn't managed properly. That's one. You also can see there's a much greater risk of suicide. That's the reason why we have a lot of anti-ligature regulations that can now come down. But you also can see a fair amount of violence from patients from time to time, both for the healthcare worker and for patient-on-patient aggression. So that's another area we see injury. But the fourth one is falls, which is the case on this one. And psychiatric patients have a, I don't know if you have a slide about this one, but have a unique risk for falls. Let's talk about it. Unique risk for falls. First of all, in a general medical floor, the chances of a fall being unassisted are much lower than on a psychiatric floor. And that's because the patients are not confined to their beds. They would be in a medical facility. Most of us have been in a medical facility. I know I have, unfortunately. I rarely got out of bed. And that's the case for most patients in a medical facility. But for psychiatric patients, the majority of time is actually spent out of bed. And so that alone is a risk for fall. But a lot of times they're being started on new medications or they're being titrated up in the medications. And a lot of these medications can cause and have significant side effects that can cause dizziness and risk for fall. Our antipsychotics do, but our benzodiazepines do. Some antidepressants can as well. So you do have a higher risk for that. One of the reasons why, hopefully, most people are very careful titrating medications up, was the case in this case, is because of that risk. So you have those reasons, but a lot of times also, a lot of our patients may be manic or psychotic, and that can cause them not to sleep. If they're not sleeping well, again, that can be a risk for fall. Also, they may not be eating well, and so that's another risk. And they may have underlying medical comorbidities that unfortunately, a lot, specifically for our patient population, it doesn't get the proper care needs, whether the patient is not compliant, or sometimes whether they're not seeing a primary care doctor, or some of the ones may be ignored by the primary care physician.
Right. So we often think about psychiatric wards in general hospitals. That's what we used to call them. You know, there would be like a wing of the hospital or a certain section of rooms dedicated to psychiatric care. More and more, we're finding these freestanding behavioral health hospitals. So it never occurred to me till this case came along, and my 18-year-old client did take a fall, just fainted cold, and it was captured on video, just fell back like a tree, and hit the back of his head. What happens? Who is taking care of these patients medically? Well, in this particular hospital in Texas, they had an internal medicine team on call 24 hours a day. The problem is they were independent contractors. There was no control over their training, their qualifications, or anything like that. And on call did not mean they had to physically come to the hospital. So they could have just phoned it in, and that's what they did in our case. And our young man's severe brain injury with a skull fracture, subdural hematoma, the works, resulted in about a 19-hour delay before he got diagnosed in a regular hospital. So there was problems with this internal medicine team not being employed or under the direct control of the psychiatrist and the behavioral hospital. There was problem with handoff between the nurses. The people who were looking at this patient the next day didn't know about the fall. And then, of course, there's the problem with the person who got the call the night of the fall, not reporting to the internal medicine team the next day when he started having basically symptoms of herniation again. So those are some of the things that I think are kind of new, or at least they were new to me. So I want to just run through a few questions. You talked to us about why inpatient and psychiatric facilities are at a higher fall risk, but what, besides falls, what kind of medical conditions can come up in this environment that requires general medical care as opposed to psychiatric care?
So we see a plethora of different medical conditions come up because unfortunately, again, our patients are not always in the best of health. So a lot of them have diabetes, a lot of them have high blood pressure, and that leads to cardiovascular disease, which is heart attack and strokes that do come up while you're on site. Also, obviously, risk of falls is another big one we see. So you can see a plethora of different disease states that appear. Now, you're always able to send patients out, and the majority of the time, if I have a patient that's got chest pain, I'm not keeping them in the hospital. I'm not going to keep them in my hospital. I'm going to send them to, in our case, it's the main hospital or Radiation Health, and they'll go there and get treated. The issue becomes if the report isn't good, or if the doc's not asking the right questions, or if, in this case, not only was the doc not asking the correct questions, it was the nurse practitioner not asking the right questions, but then people are also not following the orders and not giving a proper report back out. That's when you can see issues that certainly come up. Can I just talk a little bit more on this case?
Yeah, and talk about the intake too, if you will.
Yeah, well, I mean, when I looked at this case, this was truly kind of a sweet cheese where if everything could go wrong, it went wrong. So from the intake, where I think the patient had a history of poor nutrition, which was a risk for fall, which was somehow missed, initially checked, because they have a lot of check boxes at this facility. But then taking that, and the fact the patient hadn't eaten or slept in several days and actually put out a fall risk, for some reason that was missed. The physician, in this case, this patient was naive to any medications and started this individual on beyond a full dose of two medications, an antipsychotic at much higher dose than most of us would have started, and added a mood stabilizer for no apparent reason that I couldn't understand. So again, by putting it at higher risk by doing that, the patient then subsequently hit their head. As far as I can tell, when they called the nurse practitioner to notify, did not give a full description of what occurred. And then, as I tell my residents and I, talk with our physicians, somebody hits their head, you've got to have a pretty low, you need to really be thinking about sending these patients out. Because once somebody hits their head, you just don't know the kind of damage they may or may not have done. And in this case, they kept the patient there. The nurse practitioner then ordered what were called neurochecks to see if how the patient, actually the patient was maintaining in the bed the rest of the evening. Nobody followed those neurochecks. So the patient was allowed to sleep. And what do people with head injuries do? They vomit, they sleep. And so they just allowed this patient to sleep in between he was vomiting, which again wasn't reported to the nurse practitioner. And then nothing was passed along the next day. The psychiatrist who had put the patient on what which was the dosage which I thought was for that patient was to start with. When he came upon the patient the next day, the patient was unarousable. And at that point in time, the psychiatrist, in my opinion, should have stopped and tried to figure out what's happening with the patient. Didn't read the chart, didn't know he had a head injury, just moved on to the next patient. So the patient was unarousable because of medications. That's what he said. But didn't investigate that. So when I was looking at this, was kind of some multiple Swiss cheese where literally everything that could go wrong with this patient went wrong.
And compounded by the fact that these are 18-year-olds, and those of you who have, our client was an 18-year-old. Those of you who have children understand that 18-year-olds may legally be adults, but they're not adults, especially 18-year-old men. But they're poor historians, and I think that you probably find that among almost all of your patients. At least he had his mother there. I mean, it's so many of them are coming in on their own, or they're getting picked up and brought in by law enforcement, right? And so the doctors don't know if they have high blood pressure, or if they have diabetes, or if they have had psychotic episodes all their lives, or like with this young man, it's the very first time he ever had any kind of psychotic break.
Can I ask a question, but interrupt, I apologize, or it doesn't fit, I apologize, but for normal in hospitals, there's a worse fall scale that people typically evaluate somebody first. Is there something like that for psychiatry?
Yeah, it's in the chart.
Okay.
Just not done.
They're not done correctly, because of course, he's not gonna report, no, I haven't eaten or drank in the last 3 hours.
So typically they do that before, so they just know ahead of time. So I was curious as a psychiatrist, should you be,
It was done,
It's not correct.
right.
It was done before it all happened. It's not correct. Then they did it afterwards, after the call too. But the initial one was not done.
And this kid is 6'5", very attractive and very slim. And so was a problem for 4 years. It was a problem when he came to the hospital. He didn't look sick. And they didn't ask, you think fall risk, you think, right, a little old lady like me, you don't think like an athlete. But throughout the case, that was a problem. Not just what would the jury think when they see this kid, because he looks like a model, but he's so brain injured, he doesn't know he's hurt. And he doesn't think he needs treatment. And he sure didn't think he needed any money. So, talk to us about behavioral health hospitals providing care for internal medicine needs of patients, short of hiring them as employees. Can it be done? And if so, how so?
So I think everybody does this a little bit different. I know our facility has, we have nurse practitioners, and we have one family medicine doctor and nurse practitioner. But somebody rounds in person every day on the patients. There's issues overnight. Person that actually gets called is the psychiatrist or resident, then it's a concern talk to the psychiatrist. We have somebody in-house as well if there's a problem, because we have an emergency department that's attached to our inpatient facility. So we have a little bit, our setup, there's less risk of some of this happening compared to this facility where they have, where everybody looks like they were a contractor. The psychiatrist is a contractor, the medical coverage was a contractor, And so a lot of times what happens, there's a real lack of ownership of patients because this isn't the only thing these people are given that day. You know, this is the first 2 or 3 hours that they can put on something else. And so it brings a little bit more risk in there. They're also, this is a problem I think in general medicine is important about this too, where people are not, there's not a good communication from physician or nurse practitioner to physician, nurse practitioner to practitioner, whatever have you, and also from nurse to anybody as well, because the nursing staff knew this kid hit his head. But as far as I know, they didn't alert the psychiatrist to this. They didn't talk to the nurse practitioner family. So nobody really, the information was there, that was talking about it.
Right. And you mentioned already about the nurses not following the protocol and the order for neuro checks. In this case, the hospitals took the position that the nurses were licensed, so they assumed that they were trained and knew how to do a neurological check. Tell us how it works in your hospital. Do you do anything other than just make sure they have a valid license?
Yeah, so we do trainings with nursing staff, sometimes equivalent positions, looking at different code situations, guiding situations, obviously, where, you know, where somebody's, most of the time, our medical codes tend to be seizures, common thing we see. But you see, you know, you want to make sure that if somebody's heart stops, if the breathing stops, that your staff and physicians know what to do and how to work together in these code situations. So we do a lot of training on those lines. We also do independent training, whether it's looking at, you know, getting vital signs, if it's your psych techs or neuro checks, or that you can do individual trainings to measure people that work there, how to do these different skills.
What do you think was the biggest challenge in the case, other than the 4 years that it took to resolve?
As far as
Just about the case, what was the most challenging part is acting as the expert in this case? And the rest of
wasn't thinking about, I think, initially for me, the biggest thing was trying to understand what their policies were and whether or not they were following their policies. And as you know, it's not discovery and getting that information is not always that easy. And so it's really trying to figure out, okay, you know, if they weren't following their policies, if they're not following J-code policies, or the Joint Commission policies, but there's obviously a lot of regulations involved with medicine, and seeing where the issues were with what they were doing. Some of it was also just trying to figure out, okay, and stuff like, there's no policy that says you've got to run, that your nursing staff has to follow physician orders. It's understood, right? There's no place you could find that. So it's you know, justifying and showing why some of these things are taken care, but they really don't exist anywhere specifically.
Exactly. Well, I think that the statistics we showed you demonstrate that there should be more and more of these cases coming down the pipe. Injuries and medical malpractice in this setting. Do you have any opinions about how Brandon Dodd's case could have been avoided by the hospital?
Yeah, I mean, to me, this was, you know, I talked about earlier, it's really kind of a Swiss cheese. We saw several different things that came up. First of all, the physician medications and the amount, mostly the amount he used, really to me were far too high for a medication naive patient. And I do think there's a pressure put on my insurance companies about the hospital getting these patients out. How you get them out? You start them on as much medication as you can as quick as possible, because at least you can sedate them enough where if they are having symptoms, you're not seeing those symptoms. And then you can discharge them out. The problem with that is obviously you run the risk of number one, you discharge people way too sedated and function. So then you run the risk of them falling in different issues. And sometimes actual medical problems due to medication. So that would be number one. Number two, definitely the communication. I think the overall education of the staff understanding head injuries was very, very lax. The whole concept, they as opposed to doing neuro checks, it's more important than to have the patient required to stay asleep. So I really don't think anybody understood the gravity of what was going on. And someone was vomiting multiple times during the night, that this person needs to be transferred. So, to me, that was the other area, really educating the staff better about what I would consider some pretty not uncommon things you might see that may occur medically with your patients. I think there's a lot of times I see with our psychiatric staff, we're here for the patient from a psychiatric standpoint, really disinfect. And your psych, that's also not a lot of these patients being affected. So I think really emphasizing that we need to put our head on patients' mind for the medical issues is very.
Well, I can do a whole seminar on how not to defend a case. I know there's some defense lawyers in here, but I will not do that today. I'll just say that, one of the downfalls of having all of the people who provided care for this patient, independent contractor, is I had at one point 6 different attorneys against me. And all of them full bore press. Of course, they're all working from home during COVID, thinking of things to send me every single day of the week. But, they just wouldn't turn over anything. So if you're gonna play the card of, we don't have any liability, then turn it over, right? And you could have got, in this case, we could have eliminated 2 or 3 defendants years earlier. Anyway, thank you, Dr. Shaw, for coming and talking to us today. I appreciate it very much. Don't break your head on that.
Hey, don't trip over, don't fall, don't hit your head on the table.
The wire is so scary.
Our next speaker is John Blumberg. He's going to be talking to us about persuasion as a science. He's double board certified in legal and medical malpractice. He's going to be one of our newest board members for ABPLA. He's going to help us rewrite everything. He also helped us rewrite the legal malpractice exam that we use to qualify people to be board certified in legal malpractice. So it's be sure to slide with us. I spent enough time. So
Okay.
Welcome, John Blumberg. To speak.
Okay, thank you.
Here's the rest.
All right, so I'm a plaintiff's lawyer. I represent plaintiffs in legal malpractice and medical malpractice cases, and I do expert witness work in legal ethics. I used to, at an earlier time in my practice, defend legal malpractice cases. And I've heard with interest everybody who has spoken so far. And it's very much like what we do when we put on a trial. We're trial lawyers. And as trial lawyers and as board certified specialists, we are very good at what we do. We are persuaders. We are professional persuaders. But what I realized after 40 years of practicing as a trial lawyer is that we don't really understand how decisions are made. That is, what's the cognitive process that people go through, jurors, judges, ordinary people. What is the mental process by which information is filtered? There is no training that lawyers undergo about decision science. We learn how to make opening statements. We learn how to examine witnesses. We learn how to walk from here to there in a courtroom. But we really don't learn about the process by which human beings sort information and decide, I'll accept that, or I'll reject that, or I don't understand that, so I'm just going to let that go by. And so I'm here to tell you about a book that I wrote called Persuasion Science for Trial Lawyers, where I undertook to translate thousands of academic articles in sociology and psychological and political science journals, where this study of how decisions are made has been out there for years, but it's really hard to understand because it has to do with statistical analysis, and here's how we did this study, and lawyers take one look at that and they are reminded why they became lawyers and not mathematicians. And so I'm here to talk about this translation from something that is well known in the psychological profession, but not well known by lawyers who need to know how to do this. So, as I'm pressing a button and nothing is happening. You know, trials are like this. We've spent tens of thousands of dollars on some video or some animation or timeline or something, and we press the button and nothing happens and everybody's looking at us. But I will make this, see, this is my book. I'm not here to talk about the book, I'm here to talk about what's in the book. Are we in slideshow? This is why it's gonna have to spawn. I'm not persuaded. This would be a good time to cut away to a commercial. Yes. Oh, there it is.
There we go.
Hooray, okay.
Let's see the audio.
So, those of us who try cases to juries are interested in the answer to this question. How are jurors persuaded? And those of us who practice law, even if we're jury trial lawyers, we have to deal with judges, most of whom are human beings, and who have all of the attributes and failures of other human beings, and that is to be able to understand and to process information. So, I'll just do it now. So, our judges persuaded. The old belief was that we will put a case together in pieces like a jigsaw puzzle, and that by the end of the trial, all of the pieces make a picture, and the jury or the judge sees the picture of all of the pieces that we put together and they say, aha, now I understand your case. Well, I'm here to tell you that that's not how it works. And so we are going to talk about a reconsideration of the conventional wisdom of how judges and juries assimilate information. And we're going to start with a picture. I want you to look at that picture. I want you to think about that picture. We're going to come back to it in a minute. So what are we looking at here? Is that convex or is it concave? I see the hands of those who think it's convex. You think this is a trick question, right? So it might be convex and it might be concave, depending on your viewpoint. It's the same picture, but it will be interpreted differently depending on your viewpoint. The viewpoint may be a liberal or progressive viewpoint. It may be a conservative viewpoint. And as it turns out, people who have conservative inclinations see things differently than people who have a liberal viewpoint. And there are ways to talk to conservatives that don't offend liberals and ways to talk to liberals that don't offend conservatives. But if you don't know what is important to conservatives and you're a flaming liberal like I am, what makes perfect sense to you is not going to be received well by your conservative audience. And I'm not talking about politics, I'm talking about those things that are valued greater by conservatives than liberals. And the interesting part of this is that you can present a case that is consistent with conservative values that won't offend liberals. I talk about that in the book, and I'm not going to be talking about it here, except when I get to why certain information is rejected. So when you are presenting new information to a judge or to a juror, their mind is searching for how to understand it. And when they are doing this search, which goes very quickly, what's happening is that depending on how it's presented, they are counter-arguing. Counter-arguing means that someone is listening to something and there's a voice in their head that is saying, oh yeah? Well, I don't think so. And counter-arguing is a psychological thing that has been studied to death. And the diagram here, and there's not going to be a test on this, but this is a scientific diagram of the process of the brain in counter-arguing, that is hearing something and then essentially rejecting it. So now we know that information is rejected, but how do we know what information is rejected? We all know and have heard about confirmation bias, and this is a good diagram that talks about confirmation bias. There's all of the facts and the evidence. There is what our beliefs are, and the shaded portion of this Venn diagram is evidence that is believed. So everyone's brain works this way. Is there a lesson here for advocates? The lesson is make your case consistent with what most people already believe. And so you will never, as an advocate, persuade someone about something that they do not already believe or which is inconsistent with something that they believe. You might as well first ask a juror in voir dire, well, this is your entire background, but can you put all of that aside and be fair in my case? And most of them will nod and say, sure, I can be fair. Well, they're going to be fair in their mind, but there's no way that they're going to be fair in your case. So when you put a case together and you've got all of this great evidence, it's going to be rejected unless it is consistent with what the jurors already believe or what most people already believe. And so every case, you should go through and try to come up with what do the jurors or the judge already believe is true. We're going to be getting into this whole concept of how something is believed to be true. But these are pre-existing beliefs. What do they believe is true? What is so common in life that it has happened to everyone? So let's say you have a case where a doctor rushed a patient through an examination, didn't do a thorough examination, didn't catch the condition that ultimately harmed the patient. What do most people believe? Well, they believe that they like their doctors and they don't want to believe that doctors hurt people. And so you take that belief against something that everybody knows, and that is, how many of you have had to wait for long periods of time in a doctor's waiting room? Okay, everybody's nodding their head because that is common belief. How many of you have had to strip down and put on a paper gown and sit on a cold table for a half hour before someone comes in to see you? Most people have had that experience. How many people have the luxury of a doctor spending more than 5 or 6 minutes with them before they go off to see another patient? Hardly anybody. So these things are already believed by most people and will be accepted if you incorporate that into your case. And it can be any kind of case, just what people already believe. So let's take a look into the science of persuasion. See if I can move this thing out. There we go. We're going to take a look at persuasion science. Except now the slides aren't moving, so give me a second because the best part's coming up. This is frustrating. Give me a second. Tech people, see, Justin's going to do something on tech. And so I'm going to put a lot of pressure on him right now.
To do the next one, is that the next one?
That's the next one.
Right, here these 2 hours.
All right, so now I'll handle those arrows. All right. Let's start out with this one. If the acceptance of truth leads to a belief, then the question is, how does information become truth? How does information become truth? That which is learned, and this is the key to what I'm going to be talking to you about, what I am talking to you about, that which is learned is accepted as true. That which is learned is accepted as true. Let me say it a different way. That which is learned is accepted as true. The reason that I said that and showed that to you twice and let you read it for yourselves the third time is how something is learned. You're exposed to it the first time. It does not yet become anything other than a temporary memory and a holding pattern. The second time you hear some information, your brain now has that information and is searching for something that is familiar and finds that information that is in your brain. Now it is stronger. And the third time that they are exposed to it in a learning situation, it is easily accessed. And that which is easily accessed has the feel of truth because it's not hard to get to. So memory is the residue of thought. Whatever you pay attention to and think about, that's what you remember. How do you create memory? Memory is first starts with understanding what you're hearing. Then the brain has to process the information. And this picture is a good example of it. We start out with the question mark. The gears are starting to turn. You're starting to be enlightened, and then you get it. It's a process. Processing of information is the most important part of persuasion science because you have to give your audience time to process what they have heard. In order to process information, you have to slow down. When you're reading some information in an article, in a text, here's what we do. We're reading, we get to something that is a little bit hard to understand or it's new, and we stop. And we think about it, and we roll it around, and we might go back and look at the previous sentence. But before we keep reading, we have gone through this process of thinking about it and then deciding whether we accept it because we're trying to understand it. When we are putting on a trial to a judge or a trial to a jury, if we're not giving the judge or the jury the time to be able to process this new information, it's not going to become a memory, and if it does not become a memory, it will not be accepted as true. So the key in processing information is to pause. This is hard for lawyers because whenever we feel silence in the courtroom, we get uncomfortable, but there's no rule that says that we have to fill every moment with sound. And so build into everything you do a pause. You can be dramatic about it if you're a male and have a beard, and you can stroke your beard or twirl your mustache. Or you can turn a page, but you have to do something to give the trier of fact the time to process the information. Time to think about it. Now, the next point in processing is the easier it is to process, the more believable the information is going to be. And the more difficult it is to process something, the more uncertain the people who are your audience are going to be about the information. So that brings us to the truism that complexity is hard to process. If it's easy to process, it's believable. If it's hard to process, it's uncertain. Mental fatigue makes it hard to process. What is mental fatigue? Mental fatigue is when you have been loading so much information to your trier of fact that they can be listening, but their brain is checking out. The brain doesn't have what we now call the bandwidth, or maybe used to call the bandwidth to be able to absorb the information. So you may have a case with 100 facts. It's too much. The brain is going to check out because the brain cannot assimilate that much information. What's mental fatigue? After we have all worked the entire day And we go home. And our spouse presents some bill that you've been ignoring or something you haven't been doing. What do we feel like saying? Not now. I can't deal with this right now. That's because our brains are just tired, like a muscle that's been working all day and can't work anymore. So the other part of appreciating what's going on in people's minds is cognitive overload. Cognitive overload means too much information. Can't process it, can't understand it. If you're a plaintiff's lawyer and you have the burden of proof, as soon as a juror starts thinking, I'm not understanding this, when it comes to filling out the verdict form, the jury is going to say that the plaintiff has not sustained the burden of proof because they're confused. It's too much information. And so cognitive overload also makes it hard to process information. So the next thing that I'm going to hopefully play is an example of this from the movie Amadeus. All right. Too many notes. All of us have too many facts in our cases. We have so many facts that if we put on every fact that we think is important, it becomes more facts than any reasonable person is going to be able to absorb, to assimilate, to process. And that means that we have to trim our cases down into clumps, that is, clumps of information rather than facts. Remember the O.J. Simpson case, or if you don't remember it, you've heard about it. The prosecutors talked about a mountain of evidence. They had put on so much evidence that it was overwhelming and disregarded. I'm going to close. Oh, I did that one. I'm going to close with this. Remember this? We saw this at the very beginning. And I asked you to look at this and think about it. And in doing that, I created curiosity. When we create curiosity in our finders of fact, they pay attention. And when you bring that subject up again, they've already been thinking about it. And now it is a part of what is going to become a memory. That's why I led with that. But what I want to show you about this is I want you to think about the picture full of water as a case full of all of the information that we think is necessary to prove our case and persuade the finder of fact. And I want you to think of the drinking glass as the cognitive capacity of the judge or the jurors to whom we are presenting our case. What do we do? Simple. We can keep pouring, but it's not gonna stay in the glass. And we don't know what it is that we're pouring that is going to end up in the glass. We have to this is my big finish, so.
We got it.
And so this is the pause where I want you to think about this. Keep it short and keep it simple, because the cognitive resources of the people that we hope to persuade are limited. And if we don't understand that one concept, then we're just pouring water into the glass, and it might not end up persuading anybody. Thank you very much. And now, I'm going to introduce the tech guru, the master of technology and how it is going to be applied. And I want to see who do this perfectly.
Wait,
It's magic.
what's funny is, there's multiple things that are funny about that. One is, we are on the fly, get this on the set. We're gonna try to do something, which is, we're gonna plug in my computer, which has not been plugged in there.
What's that? What is supposed to, that's for the hour? That's all right. Yeah, no, I know, I forgot I'm dealing with David, so let me keep it short and small words. Yeah, hold on. What I'll do is, I'll let him start it. Oh. And first of all, I want to thank everyone who has spoken today. I learned, I've already started thinking about looking for cases where somebody, most cases, candidly, if it involves psychiatric matter, probably not going to look at it. But when a doctor prescribes medication to somebody who's going to be walking around, I thought that's a fascinating way to go, and then not watch them fall. I don't know where Bill went. Ronnie and Eric made me think about the Murdoch case in ways I hadn't thought about. Bill gave us a new tagline for NBT, it's built in appeal. Your stuff is fascinating because as you were talking, I've been listening to you for years, whether it's consciously or not, I've been implementing a lot of the things you're saying in terms of trying to slow down. It's very difficult for lawyers to speak slowly because you feel like you have to fill this emptiness. And sometimes when I'm teaching law students and lawyers about cross-examination, you feel like, oh, there's Bill, sorry, I didn't see you there. I was talking about you. I said you gave us a new tagline. When you're cross-examining and you ask a witness a question and there's this silence, you feel like you're losing, but you're not. As long as the jury gets your question and they understand why the witness should not be silent and why they're overthinking things, you're okay.
I don't know. Where's your Zoom?
Oh, well, the Zoom should be, well, you should, you.
There you go. Okay, you look.
So is it running?
Yeah.
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 Well, you got it. Oh, it's over here. So it's over on the side. So where do you want it to be? What you need?
You can get it up and running.
Okay.
Thanks for running.
So tell me what you need, Ed.
Being short, I like to ask the group, how long
I don't
would
know.
it take?
Like I'm trying to figure out how this is it, but I don't know how to share it in your son.
Oh, I'll take care of that. Well, once it's running.
Spoke for 2 hours, was a known orator, and his speech Not a word
Well,
was remembered.
But see, it's,
The most impressive and memorable speech was Lincoln's, and it lasted 2 minutes. Keep it short.
it's right here, launch meeting right here. This is where you are.
Yep, all right.
There you go. All right, well, what I might do is what I might do is for people watching by Zoom, they might miss it. I mean, because we'll figure it out. Let me do my talk and then we'll.
All right.
Is that all right? That way y'all have the benefit of the people on Zoom on. All right. So let's talk about, do a couple things, using technology to win cases. I want to talk about like 3 or 4 different topics in the time I have. I want to talk about how to create and use certain kinds of slides to persuade. I want to talk about ChatGPT. I'm going to tell y'all everything ChatGPT told me to tell you. Yeah, I want to talk about an IPVO, which is a document camera. I'll talk about some of the apps, some of these various apps, how you can use them in your practice and in trial. First thing, I want to show you some trial slides. I had a trial about 3 weeks ago. And I want to show you some of the slides I used, because John was talking about the jury is, at least in South Carolina, I'm not sure your jurisdictions, but typically the jury doesn't want to be there. And so they want to feel like they've got something, and they also probably don't understand something. You as a trial lawyer, you can work on this case for a year or 2. You've got it in your head, and you've forgotten what it's like not to know it. And so you have to practice giving the information to somebody without providing cognitive overload in a way to make sure they understand. But I did that. I made it blank. So we were worried about?
Yeah.
I did that on purpose. What's fascinating? I was trying to freak you out. I do. How many of y'all make me go blank on purpose? Like 1, 2, 3 or 4 years. What happened when I did that on purpose? Freaked him out, freaked John out. But I did that on purpose because now you look at me. So in the middle of trial, when you were talking, you have a slide up, and I started talking about, how you can persuade. Many of you right now are going, what's this house got to do with what he's talking about? And you have to be aware of increasing the cognitive load and the distraction that takes place when somebody's trying to process what you're saying versus the images on the screen. So that's that, and I got that out of your book, I'm sure, along with Professor Richard Meyer. Anyway, so the way I started off this trial was this. I said, my client, like many people, lived in her house, and one day she got a summons and complaint served on her. And this document contains some information that told her this law firm was going to be foreclosing against her house. Why are we here? Isn't that fun? Now, it's simple, right? I tried to do stuff with audio, with sound, audio, but I was trying to take into account all these different things. That image that you saw, I had ChatGPT generate this image. I said, draw me a house, basically, and we'll go through how you do that. And then I took a copy of the summons complaint, and then this, we're going to go through how I created it using a website called presentermedia.com, where you can drop in logos from different entities and attach them to other things. So we'll go through that. So then I went through and said, this law firm wasn't just foreclosing, this is a class action lawsuit. And this law firm wasn't just foreclosing against her house for allegedly unpaid homeowners assessments. They've been doing this all throughout the state of South Carolina. And they've been collecting over $15 million a year. Objection. There was an objection, so I made the screen go blank. Judge dealt with the objection. And she said I could say that because that's what I intend to have the evidence show. Now, I don't have it here, but I had a slide that had $15 million on it. And so I said, okay, where was that? And started over to put up $15 million. So another thing, now I'm jumping through parts of my opening, but again, I don't need to. Right back to John. But one of the things I thought about was, how am I going to explain to the jury what a lien is and how it affects somebody's house? And this law firm is lying about it. That is, when they are claiming a certain amount is owed, they're making up an amount of attorney's fees that doesn't exist anywhere but their collection software. It doesn't exist with the homeowner association. And it's a lie. And I was running today, and I shit you not, I realized what word is in the lien. So what I said is, ladies and gentlemen, jury, every time you're going to hear about a lien in this case, just remember, It's a lie. How much fun is that? Oh, it's like, you like laugh. Money. Anyway, so look for things like that. Again, how can you work your words and these changing images into your persuasion that normally wouldn't be doing? So that's an example of that. So I was trying to explain to you why we are here. This has a lot of words in it, but I wanted to explain that this is another perfectly good example. As I'm talking to y'all are reading the words. And as I continue to talk, you can't pay attention to that. And that's what Don was talking about with cognitive load. This is a perfectly good example of your job as a lawyer when you are presenting information to the trier fact, judge, motion hearing, whatever it is. Your job is to decrease the cognitive load. The more you increase it, the less the information can be properly processed and you have problems. So this is another slide that I had ChatGPT generate. I said to ChatGPT, I want an image and I want to show two paths, a dark path and a proper path, a truth path or light path. And so I had it came up with this. I'm like, that is really cool. And you can tell ChatGPT to tweak it and modify it and make it a little lighter or darker. It didn't quite do that. So I said, basically, this law firm had a choice. They could go down the path of telling the homeowners the truth, which is we're charging the homeowner association $65 to file this lawsuit or to move forward. But we're telling the homeowner $425 because that's what we think it's worth. Or they could just say we're charging the homeowner association $425 when that wasn't true. So these are about the choices the defendant made. You could use the slide for any, the defendant. I used to be on the plaintiff side, sorry. So for the defense lawyers, I guess you could say the same thing. The plaintiff had a choice, and they could go down one path or the other. And this is another fun one, where I talked about the system this law firm had in place, where they were trying to get these liens out as fast as they could every day in and day out. They're trying to get over 100 of these liens out a day, $425 a pop. So this one lawyer was collecting or charging for $42,000 a day. Now, how do you like this image, right? Now, the other thing that was going on is the right here, these documents were actually from the lawsuit or from my client. And again, using this presentermedia.com website, I can take the top image and drop it on top of this other thing. So you can use this with all your different kinds of cases. Again, with presentermedia.com, you can create various kinds of timelines. And so I was explaining to the jury the process that the law firm goes through is they basically get this information in from a homeowner association and they put it in their collection software. Again, you got that clock. You're going as fast as possible, right? The other thing that's going on is, and I think I have a slide on this. I can't remember if John talked about this. It's the concept of segment. When you're introducing a lot of information to people who they're not familiar with that information, you have to break it into big pieces. If I just put up a slide that outlined that entire process in one page, that's just too much for you to take in. So you have to break it into big pieces for them to process it. So the first thing they did is, and that's why I'm introducing one thing at a time. The first thing they did is put stuff in their collection software. They would then bill the homeowner association $65. They would tell the homeowner clearly over $425. Then, but they don't tell the homeowner they're only charging $65 to the homeowner association. They would then send documents using these numbers that weren't in the homeowner association account. They would file these liens. And see now how it worked in this image that you've seen from the beginning, so then you now understand that this is about foreclosure and some other things. And then they collect money. So you now understand this process as I'm telling you about it verbally. I tend to not like to use as many words as I've got on the screen, but some of them I needed to do. So you've already seen this one myself is, and then I was walking through, they weren't attorneys entering numbers in collection software. Again, I'm trying to break it in 8 pieces. Y'all probably already get this, so I can buzz through it a lot faster. I had explained to the jury that the law firm called these people who did this the lien girls. That wasn't something I called them. Then I was going to ask the jury to stand up and give a verdict to help all the people in South Carolina understand this was wrong, blah, blah, blah. Now, I say blah, 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 because y'all get it. But just that image of that I got from presentermedia.com too, and was asking for that kind of money. So here's this website, and you can go to it. I think it's like $100 a year. And you basically go, it's presentermedia.com. you can type in search terms to look for, say file folders, for timelines, for all kinds of things. It actually generates, they have preloaded templates of PowerPoint slides, keynote slides, GIFs, static images, and other sort of things you can just drop into your slides. So basically, at the top, I put in, for example, I put up here, I just wrote the word timeline. It searched and it generates all these different, it's got probably 8 different rows of stuff I could get to. And just, there are already timelines that are done. So you can download these PowerPoint timelines, they're already done in different formats. And then tweak them to your heart's content. You can even customize stuff. So let's say you have some point to make, whatever it is, you can drop in whatever it is you're trying to talk about. And they've got the GIFs that will move and point them out. So that's just a fun thing. So here's one. I had a case against Davis in North Carolina that they gave somebody with a prior DWI and his license was not current at the time they rented it in the car. I created this sign to use. That's just sort of a cool little image, I wanted to have the decision making where it took place at Davis Budget Group's corporate headquarters. So I took their logo and dropped it on a corporate table. And so it's just neat things that you can do to create these images in somebody's head. What's going on here is Davis Budget Group is putting sales over safety. That's not what they should be doing. And so I've got, they got upselling, features, training. So these are all the things I'm putting in there, and it just generates the stuff. And for $99 a year, I think. I even have this. Davis Budget Group is giving out these keys to everybody. And so even just this logo is, anyway, so I just want to give you all some ideas about this stuff. Again, I took, so basically with became product, just the law firm was doing, I took that logo and I had it entered on top of a foreclosure sign that was already there, centermedia.com. So, right, so that this one buzz for that, give you all some ideas about using visuals.
Justin, you didn't get any objections to any of that?
No, and I was thinking, one objection I got is I had a slide that said they were earning $15 million doing this over period of class. And judge, I said, Your Honor, that's about 10 visual stats. I didn't, the answer is no, I didn't. And also, there's a lawyer who's on the other side who gets up with a legal pad. And I call him the silver fox. I've had these for years. He can get up and just say whatever he wants to ensure he's like. That doesn't mean he did anything wrong. I mean, he can just say that with a straight face, and I'm thinking, well. Anyway, so he's really good. So I think it was part of that. I didn't know how he would handle that, but I actually had prepared a slideshow presentation where had there been an objection, I could jump to it where it didn't have as many images, just in case.
Did you win the case? I'm sorry, I have to,
We were, the other side, the other side said it would take 3 weeks to try. I told the judge it'd be like 4 or 5 day trial. 2.5 days into it, they came up with more money coverage.
Wow. Nice. Good job. Justin, I gotta ask, what's up with the little animated guys? I mean, is the court okay with looking at this or that?
It's fascinating you say that. All right, we'll talk about that. It's a trial. Sure.
You get away with that.
What's misleading about it? What's wrong? I mean, here's my. It's not evidence. It's open. Judge gonna say right before it, we as plaintiffs lawyers get out. What's the first thing the judge says? The last thing the jury hears. What this lawyer's about to tell you isn't evidence, but go on, lawyer. That's the first thing to say. So my argument would be if the judge said something, Judge, I could get up and say this, and your lady's just typing there doing all this stuff. Or I could just play it and be much faster.
I love it.
Okay. So you gotta prepare to deal with it. It could be that the judge shuts you down, but then you just have to plan on just like technology failing. What are you gonna do? So you got some blow-ups and you're ready to go. Right? But I had a series of I had a slideshow ready to go if there was an objection. It took out a bunch of images. Just in case. So this for people, some of y'all have been playing with ChatGPT. I want to talk about some of the things for those of you who haven't. What it is basically this large language model. It doesn't cost that much. You can try it out for free. There's some issues related to speed when you try it out for free, but basically you're communicating with something that has been, oh, well, actually, I'll show you. I asked ChatGPT, one of the problems you have is if you're doing the free version, it might reach capacity and be slower. I have found with being on the East Coast, around noon, on East Coast time, things slow down up here. Everybody in California started to go online. But, so I started paying for the full version. I'll show you some cool things you can do. But basically, what it is, don't overthink it. It's just a fancy computer model where you can ask it questions. And you type in something down here, and you can ask it almost anything. There are certain ethical issues which will be on today about what happens to don't upload client personal identifying information, stuff about your client, but putting all that stuff aside for a second. You can ask it anything. And so as trial lawyers, what are the kinds of things you want to ask it? That's what I want to try to get you to start being creative about. What can you ask it to help you with your practice? So I said, hey, I'm going to be talking to lawyers about ChatGPT. Hey, ChatGPT, explain yourself to a lawyer. I'd lower. Yeah, here's what it said. Here's what it says. Imagine you have a really smart computer friend. This friend has read millions and millions of books, articles, and conversations. So whenever you ask a question or need help with something, this friend can give you an answer based on all that information that's read. It's also important to use it responsibly to make sure we're aware of any biases they may have. So that's ChatGPT explaining itself to y'all. But that's where I'm going to start suggesting to you use it to help you with jurors. So some of the things you can ask or anything can be like, how do you boil an egg? So it'll give you a simple, it'll give you an explanation about that. So instead of just simple questions like that, how can we as lawyers do something like, why was Andrews right and Cardoso wrong and Paul's right? I literally asked it that. And it explains it. Now, it doesn't matter whether it's exactly right or not. It doesn't care. It's just like, I have this information, I'll tell you whatever I think. So, how about this one?
What's the conclusion?
I've
been wondering since law school.
The plaintiffs' lawyers are going to get screwed. That's what a conclusion is. They are plaintiffs. So, this is what I want to try to get you to start doing is to think about more complex questions to ask ChatGPT to get more meaningful responses. For example, a buddy of mine in New Jersey, John Monroe, and I go around the country talking about AI and technology. He's written this whole thing that he basically told ChatGPT, assume you are a very conservative judge in a jurisdiction where you don't like plaintiff's cases, you think the docket's not moving fast enough, you think plaintiff's games aren't worth it, and it's a whole bunch of bad stuff. Now, consider this motion and ask me one question at a time about why I should be in your court. And so now it starts simulating a judge. And so you start putting on your worst case against yourself to sort of figure out how to plan things out. So here's an example of that. So I said to basically simulate the oral argument. And so basically I put it back and I said, simulate an oral argument where you're the judge questioning me as the attorney and challenging my position on the motion. And I uploaded the motion and it spits out. That's the idea. What it says isn't as important as the fact that you do it. That's what I'm trying to get you to think about. Is start using the artificial intelligence to generate ideas, not simply conclusions. So this isn't doing one step at a time. Counsel, before we delve into specifics of your motion, I need to understand the basis of your argument clearly. Number one, and it's just doing it, so it's just giving me an opportunity to test out what a judge, you could certainly upload decisions by the judge and say, hey, now that you've read decisions by the judge, now question me, has that judge about blah, blah, blah. So I said, this is what I said for an opening statement in a medical malpractice case involving a doctor removing the wrong leg. What is a 3-word theme using alliteration that will be persuasive for the injured patient? Why not? Why help? So the first one it came up with was reckless removal ruin. That's all right. So I said, no, give me another one. It doesn't care. Just ask it again. And I said another. And what it said was devastating doctor's decision. That's not bad. Right? And so just ask it stuff. If you know things work in trilogies, why not ask it to give you trilogies about alliteration and other stuff? So, how will the defense lawyer try to blame the plaintiff in this case? This one with a doctor removed wrong leg. And of course, it's still a made-up fact. Now, it came up with this. it said, stuff just flew by, but one of them was a pre-existing condition, suggests that pre-existing medical condition, complications, more complex. And so it came up with a list of stuff, which I'm trying to buzz through so you can see. But it's like, you don't know until, so by seeing this stuff ahead of time in depositions, you think, doctor, you're not saying my client has a pre-existing condition. How about read the attached transcript of a deposition? So I uploaded, and this is in the paid version. You can upload documents like deposition transcripts. Read the attached transcript of deposition of a lawyer who's a debt collector and whose law firm is being sued for fair debt collection practice act violations by the homeowners. And ask questions as the plaintiff's attorney about ways. I'm asking you, help me cross-examine this witness based on this deposition. And then it had key points and it had suggested questions. And I said, hold on, tell me by page and line number where you're getting those questions. So just tell it that stuff. I have one for those of you in Texas. I said, write an opening. I uploaded some facts and some documents in this case. And I said, write an opening as article here. It had great press. Oh my God, it's so good. I don't know how what the judge could do with me, but it's like, think about what this would mean to you. And I was like, I don't know if I can say that or not, but okay. Now, whether it was truly Mark Lanier or not, just you can ask it to do it in the voice of someone else or as a different person. So just play around with stuff. Now let's jump to image creation for a second. In ChatGPT and some other AI tools, you can now ask it to create images. As you can tell, I like to use images as background, so those are words. So I uploaded this morning a list of all the speakers and topics, and I sent to ChatGPT, generate a slide that I can use as a background image for this talk. Now, notice some of these. So it's got stuff with the Murdoch case. Persuasion is not spelled right, but it's sort of not too bad, right? It sort of looks like it could sort of fit, but it's throwing in words that don't make any sense. So I said, no, I said you got misspellings, and anyway, so it's not quite there, so don't just throw stuff up. Anyway, so I kept telling it, don't use words, just use images, and it still wasn't quite getting it. So these are all the different ones that came up. So I said, show an image of a jury deliberating. That's not all right. And I literally said, there should only be 12 jurors. I said there should be 12 jurors. Anyway, so it didn't fix that. So now jumping completely to a different topic, or to a different concept or text tip is transcript pad. This is a cool app that you can buy. It's available on iPads, and you can also run it on a Mac. But basically what it allows you to do is you can create a file within this app. You can upload import materials like the text file, the deposition, along with the video deposition that you took. And it will then synchronize them. Then you can select the parts and then export them for trial. So instead of having to hire a third party to do all this stuff, you can do it fairly easily. So basically, you upload the stuff, you throw in the video clip and then the text, and it in the background will synchronize all this stuff. And then you can start doing stuff where you can then play the various parts of it, and it will automatically generate the text below it if you want to do that. So I think it ranges around $600 or so for the whole suite. But by the time you pay a videographer and other people to do that stuff, it might be something you're interested in doing. This device right here is called Plod. It's Plod AI is the company. They've got this little device and another little one that I've got in my computer bag. When Ronnie and Eric were talking, in the back of the room, I had this thing going. It recorded it. And it was doing a transcript from the back of the room without a microphone. And it will generate this up. You can see up here where it says summary and mind map, because it was so far away it doesn't quite work. But you can put this, your ethics rules may vary, but you could have this in a deposition. Then when you're getting home or later on, it'll summarize everything for you and make mind maps and some other things. So it's a cool little device. You pay a subscription fee a month, 20 or something bucks. You buy the device for a couple $100. But anyway, that's a cool little device. So basically, so it records the sound and then it generates based on whatever, spits that out. This is a cool tool, and I'm watching my time because I was making everybody else. I at this trial, I had a Oh, yeah. So y'all are getting ahead of me, but anyway, so let's see if I can just, you still remember what that is? Some people call them door presenters, right? I still think it's funny that, not funny, because what you were freaking out about me making the screen go blank, I did that on purpose. But there's. Yes. All right, so what's going on is this. Yes, it is. Y'all are thinking. So what I was doing in trial was, now I've got a different one for trial, but conceptually, this is the idea. You can have this mini document camera, and then you put documents underneath it. It is. So one of the things that I find fascinating is this, because, and I think I think Richard Meyer's in your book, probably, right?
Yes.
Multimedia learning. Richard Meyer is a professor out at Stanford who studies how to teach best. And he's got all these books, and I've got them on multimedia learning. And one of the things that I find fascinating is this, as high tech as I like to believe I am, this is an interesting article by him, The Effects of Observing the Instructor Draw Diagrams on Learning. That is, he has written about how people learn better when you write things out in front of them. So during this trial, when I had a witness up, I would have a document there and I'd say, well, hold on. You're talking about this right here, right? Or whatever it might be. And if you're highlighting a document, you know, it's like, so you agree with this statement right here, right? And to see that take place in real time is helping the jury understand. It's the equivalent of a butcher paper kind of thing. The other thing I did was when I was asking the one of the lawyers, you know, how much money did y'all take in again? I had a little note card and I wrote down $15 million. You know, they were objecting, and I moved to put that document in evidence. The other side objected, and judge's like, I'll let it count as demonstrative aid. She also, well, sorry. So the other one goes through IPVO. That's a tool called an IPVO. This is a portable one. I suggest getting one that costs about $200 or $300, which has a higher resolution camera and some other stuff. But it's basically connected in real time. The other thing I did at trial, and I know I'm late. In real time, and I had not thought about this before, but this is the slide where I put the slide up. I showed you on the slide. I wanted to cross-examine one of the witnesses about this to have them bless it as being accurate. So when she was on the stand, this is one of the paralegals, she said, that's not exactly right. And I'm thinking, crap, I don't want to seem like a liar in front of the jury. I said, well, hold on. So I just, in real time, I put up the slide and I said, let's walk through how it's not right. And then she told me, and then we ended up with a slightly different version, which is this one. So in real time, in front of the jury, like with y'all, I built this slide. I said, so you agree this is now right? Yes, thank you. So now I was going to use that in closing. And it's like, you remember, she said this is right. So anyway, I'm showing that because I've never seen anybody do that before that I know of. And I thought that's a sort of a fun, in real time, that wasn't how I planned on it going, but I thought it was fun. I'll talk about a couple other things. In Adobe Acrobat now, if you have the paid version, you can have it AI within Adobe Acrobat. This is, in my mind, one of the differences between Adobe Acrobat and ChatGPT is you can have it analyze the document. And one of the things that it does is you'll summarize it. You can tell it to do certain things, right, in question. And it puts these little notes here where it will then tell you where in the document it is getting that from. So you can upload a deposition or an article. There's certain page limitations. But the idea is it's sort of cool because then it can actually tell you where it gets that from. So you can sort of double check it. So I just want to buzz through that. I promise you, I'm aware of, I teach law students too. So, I did want to talk about this, then I'll stop. This to me is the idea of segment. And I think, if nothing else, I think it's an important idea. Talk about it in this example. Ladies and gentlemen of the jury, This is very simple. It's about network. Right, most people. Right, that's way too much information to give. And so you as a lawyer have to remember this slide and say to yourself, how can I break this into itty bitty pieces and present it one piece at a time in order for them to get it? Ladies and gentlemen, this is a case about network. What is networking? Well, many of you have heard about the cloud space of the internet where you get this information from. Well, that internet is connected to your house or to your office through something that's called a firewall. And that firewall, its job is to keep bad stuff from coming into your office and prevent the good stuff that's in your office or home leaving. That's then connected to this thing called a router, which then connects the various computers in your home or office. And some of y'all might have heard a Wi-Fi hotspot. That's just a device that's hooked into the router that wirelessly connects these various computers. And that's basically a network. Now, I promise you, I would have done that much slower, but because of the time, but look at the difference of how you introduce a piece at a time to help lower the cognitive load in order to help people understand. I guess I go one more. This is, y'all just let me know when we go. I had a case involving Klein's line, which, how many of y'all familiar with slip capital femoral epiphysis? Ooh, all right. So I had a case where a 11-year-old girl went to a chiropractor. She was in Myrtle Beach, South Carolina, ended up with slip capital femoral epiphysis. And right now, many of you are going, what the fuck are you talking about? What John was talking about. And so now you're like shutting down because you're not understanding what's going on. So you have to recognize that. And so basically what's going on is there's the femoral head right here. Normally, when you're growing, there's a epiphysis, there's this growth plate right here. And when you're younger, it's sort of squishier, mushy. It's not quite formed yet. And so that femoral head can slip. And that's called slip capital femoral epiphysis. If it moves such that when you draw a line along this area right here, it doesn't transect the femoral head, then you know the femoral head has slipped too much. And this line is something called Klein's line. And so basically, when a radiologist looks at a slide, you want to make sure Klein's line transects that. And I thought, you got to come up with a simple image for a jury. And I thought, everybody will get, when you get a scoop of ice cream, you want the scoop to be over that edge. And so when you're drawing the line, if you think about like the femoral head, you want the scoop to be over the edge. And so then I had the doctor explain how she messed up on that. But anyway, so I swear I'm what? Oh,
Can I ask one question?
only if it's one.
So if technology keeps going in this way, what would stop the courts from eventually saying, we'll feed the facts to this AI thing. We know what the outcome will be based on precedent. And here it is, it'll spit it out and we don't need lawyers and we don't need any. Why not?
I've got a clip from Star Trek from the 1960s that I won't play that deals with that. I mean, I think courts are going to have to be dealing with that. Some courts have already started to figure out how AI is going to play a role. And I think your job as a lawyer, I mean, first of all, in criminal cases, a client has a right to cross-examine a witness, not a machine. And so there's a criminal case called, something with Massachusetts. I have a different series of slides on this, where basically a criminal defendant was being accused, or the evidence against the criminal defendant, what the United States Supreme Court would read, the machine, which basically said that heroin or cocaine was in the mixture, wasn't capable of being cross-examined. So the government couldn't simply use that as proof that the person had a right to confront that. So in my mind, Menendez versus something else, Maine, Massachusetts, somewhere. So I think that's going to be part of an argument plaintiff's lawyers can sort of build off of. Plus, I don't know that it's an enemy so much as a tool. That's all I think this is. It's just, it helps you. I've tried to show you examples of how to help you be more persuasive, not to make decisions. It gets shit wrong all the time. Just to make stuff up.
Two things. So one is, I think we're about out of time.
Yes, we are. Thank you. Yes.
Dr.
Normally I didn't pull myself up.
Dr. Rochelle has been waiting in case anybody had any
Oh,
questions
absolutely.
for him.
Yeah, no, yeah, and I promise, there's a happy hour thing tonight, everybody's going, I'm glad to answer questions and do magic tricks, which I will. I appreciate y'all, and please answer questions he has, ask him questions, but I promise you, I've watched my time, so I'm done. No, it doesn't hurt my feelings. So, okay, keep going.
Can we vote on that before tomorrow?
Vote on what?
That the ABPLA.
Yeah, I think we did.
Approves. Approves the MBTA joining the American Civil Trial Bar.
Oh. Are you at the meeting tomorrow? Oh,
But it has to happen before we merge.
I thought I was given, y'all don't have to hang up this part of it. I thought the board meeting, I was given the authority to effectuate the stuff. Does that not count?
That's a separate.
All right. I'm not trying to avoid it. Let's send around emails. All right, let's just.
Well, the American Civil Trial Bar Roundtable, the ABPLA has a seat that they work hard to get. The MBTA does not have a seat. So it's soon the American Civil Trial Bar Roundtable will take up allowing the MBTA. Tomorrow, the NBTA to agree that BTA should be.
We all different board members over here.
I'll report it. Thank you.
Thank you. Yeah, so y'all have any questions? Dr. Schnell's here.
On the project, treatment centers, they subject to joint commission investigations and